I'm Dennis Rosenbaum, the COCO, and we thank you all, members of the COAB and others from the community and the city, for being here and being part of this very important process in the city of Portland. Some announcements here before we get started. We're going to try to stay on time. The tables here in the middle are for COAB members and presenters. If you're a visitor, we'd like to ask if you take a seat around somewhere. Hopefully there's enough room. There's sign-in sheets and meeting materials are behind me here on the stage. If you're a member of the public, would like to make public comments today, please be sure to indicate that on the visitor's sign-in sheet. That sign-in sheet is also where you can sign up for our email list. Our public comment periods will happen tonight at a couple times, right? Early on, and then about 8 o'clock or so. There's food and water at the back, and please help yourself. Restrooms back that way and maybe elsewhere. Wheelchair accessibility bathroom on this floor, and additional restrooms down one floor. If we need to evacuate the building, I guess I need to announce this. There are exits on the south side of the building beyond the restrooms, on the west side toward the parking lot, and on the north side, this behind us here. Brad Taylor, where are you, Brad? Here he is. Brad is the city's mental health specialist. He's available if anyone needs assistance this evening or would like to request accommodations. Thank you, Brad, for helping us. And I just want to get started, just a brief overview of the agenda tonight so we can stay on schedule. Most of the meeting hearing presentations will be on the history and the content of the settlement agreement. I'd like to be the first to acknowledge that this is something we should have done actually early on in our first or second meeting. It's a foundational information, and there's a lot of more foundational information we're going to pursue over the next couple months, but I think this will be incredibly helpful to get the background. Jonas Geisler is from the United States Department of Justice, and in consultation with the COAB's Executive Committee, is leading tonight's settlement agreement sort of 101 training. We'll also hear from guest speakers from the AMA, the Disability Rights Oregon, and the City Attorney's Office. The training is really broken down into two parts, and we have time reserved for COAB questions at the end of each part. It's important to note that we're not going to be able to cover every detail tonight and hear everyone's perspective. It's one night, but we will have more time reserved later. At the end of the training session, we will hear from people on things that we may have missed that needs to be covered in more detail in future meetings. So please speak up when the time is right. Before I hand the meeting over to Jonas, we have two opportunities for public comment tonight at the request of the COAB Executive Committee. We'll hear from a few people now, and then we'll have additional time for public comments after the settlement agreement training later in the evening. Amy Ruiz here has a sign-up sheet that please see her if you'd like to add your name to that. So we're going to start. We're a few minutes behind already, but we're going to reserve just 5 minutes, right? Is that up front? And then more time later for public comments. Amy, do you want to take over?
Yes, we have 3 people, so it'll be 6 minutes. We have a microphone in the back, and I have Joe Walsh, Constantine with IPR, and Ann Casper. I've got a timer up on the screen to help.
Represent Individuals for Justice. Can you hear me? It's on? Okay. Individuals for Justice is a little confused. We're not exactly clear on what the mandate of this body is. We originally thought that you would have some authority. But reading the settlement and reading the charge, it seems to us that you are advisory only. And how does that work? If you advise the COCO on what the citizens are saying, why isn't it that we don't directly talk to the COCO instead of having the in-between person? That didn't seem to make sense to us. We honor your service. We know that you're working hard, and I know personally some people that are on this committee, and I love them and trust them. But we need a clarification, and if this group is only advisory, then will you be disappointed down the line? Because in our minds, this is the way it would work. And if I'm wrong, please tell me I'm wrong, because activists live to be wrong. Because that way it's not as bad as we think it is. You listen to our complaints, and you take it to the people from Chicago, and you give them a report. And then they give a report to the chief of police or the mayor or another body that is advisory also. My point is, at the top of the pyramid are two people that sit, that make decisions. Chief of police, mayor.
Thank you.
We need, what, just let me finish. That was 5 minutes? 2 minutes? I thought we had 5.
For everybody.
Oh, okay, I don't want to take time away from everybody. But anyway, would somebody explain that to us? Thank you.
Thank you, Joe.
Constantine?
They've been hanging around with Charlie.
Check, check.
Good afternoon, everybody, COAB members. Thank you for your service. Other members of the public. My name is Constantine Severe. I am the director of the city's Independent Police Review. We will be doing a series of public meetings about police accountability, IPRs, part in the process starting May 27th. It'll be at the Portland building. The next one will be in June at the Charles Jordan Community Center. There are flyers in the back, or I guess in the front of the room. I don't want to take any more time. If you have any questions, feel free to contact me. Thank you.
Thank you.
Ann Casper?
Buongiorno. I just came out of Italy, so I just want to say hello and welcome from Italy. And I was with peers there in Italy too, peers, people with mental health issues. I'm somebody with mental health issues, been with the police in and out when I'm not doing well in Japan and also in Portland. And in 2006, when the Mayor Potter asked me to be on a committee with the police, I sat in front of them in front, and I'm like, how could you do this to our community? And we actually came together over the years and got to know each other, and it's been quite the journey. I'm very grateful for that. I've personally had I'm on a committee, I've helped change training actually with peer awareness, and I feel so respected now, where on that committee I didn't in 2006. So I see hope now. I know this must be a very difficult committee. The magic here is building community. I mean, we may have this process, but we have Portland forever. So I want to encourage you to really get to know each other, and that way we can really empower each other and get to know each other. So I'm here just to say I'm disappointed tonight is you're going to have someone speak about what the mental health community feels, and the person who was asked was Bob Jundeff, who happens to be a professional. And I think it's great. I love Bob. We work together a lot. But it's not somebody with mental health issues. It's not a family member. It's not somebody personally really connected to it. And I want to encourage you in the future to have that, because it's so important, again, that we get those voices and we also really do get to know each other, because by that we can make solutions together.
Okay, we're going to move on now. Jonas Kistler will present for the United States Department of Justice and lead us through this training session as well. Thank you, Jonas.
Good evening. Actually, to start with, the United States is not going to give the initial presentations. The first 15 minutes will be by the AMAC on the background, so if I could please invite the AMAC forward.
First of all, I want to say good evening to each and every one of you, members of the COAB board and the COCO administration, to the chief of police, to his staff, to the IPR, Human Resources, and the various committees of the Citizen Committee. We are thankful for this time to just present the history in the perspective of the AMA Coalition for Justice and Police Reform. This is a history that we will be covering, and along with dealing with the concept, the original concept as we saw it for the COAB and COCO. I come before you today as the chairperson of the Albina Ministry Alliance Coalition for Justice and Police Reform, a coalition that has consistently advocated for police reform in the Portland Police Bureau and the criminal justice system for the last 12 years. The Albina Ministry Alliance Coalition was formed out of 25 community partners 12 years ago in response to the killing of an unarmed African-American female named Kendra James on May the 5th of 2003. In that response, over 5,000 citizens of Portland community of diverse faith, ages, races, united together for justice for Kendra James. It was at that time that many community leaders and community organizations, labor groups, faith houses, activists, felt the need to create a broad-based grassroots coalition to address the issue of police using excessive and deadly force unjustly against the citizens of the Portland community. The Albina Ministry Alliance Coalition focused on 5 major goals, which included 1, a federal investigation by the Justice Department to include criminal and civil rights violations, as well as a federal audit of the patterns and practices of the Portland Police Bureau. 2, the strengthening of the Independent Police Review Division and the Citizen Review Committee, with the goal of adding the power to compel testimony. 3, a full review of the Bureau excessive force and deadly force policies and training with diverse citizens' participation for the purpose of making recommendation to change policy and training. 4, to lobby the state legislature to narrow the language of the state statute for deadly force used by police officers. And 5, to establish a special prosecutor for all excessive and deadly force cases by police officers. As you can see, what has been going on in the country the last 2 years, the AMA Coalition has been 10 years ahead of these type of actions. The Albina Minister Alliance Coalition sent a request to the Department of Justice with the endorsement of 2 Oregon senators asking for a federal audit to the Portland Police Bureau of patterns and practices in the use of excessive and deadly force. We want to say that also, in light of this, the AMA Coalition following the Kendra James case was either the leader or the supportive advocate for a variety of excessive force cases, including James Jahar Perez in 2004, James Chassie in 2006, a 12-year-old young girl, teenager, that was shot by beanbags at TriMet in 2009, Aaron Campbell in 2010, and Keaton Otis in 2010. It was following the killing of unarmed African-American male in distress over his brother that in the Aaron Campbell case that was killed by a Portland police sniper on January the 29th, 2010, that mass demonstrations broke out in different communities throughout the city of Portland, that both the Albina Ministerial Alliance Coalition and the City Council and Mayor Sam Adams called for a federal investigation of the Aaron Campbell case. But this investigation did not go far enough. And it was here that the AMA Coalition called for an audit of patterns and practices of the Portland Police Bureau. I want you to understand that this was an evolution process that took place. Later we found out that the Councilman Dan Salzman and Mayor Adams also joined us in the audit for the Portland Police Bureau. I want you to understand that in light of that historical context, the Minister Alliance in July 2013, the City Council of Portland accepted the Albina Minister Alliance Coalition for a collaborative agreement continuing and outlining the Albina Minister Alliance Coalition and participation in the implementation of the settlement agreement. In February 2014, Judge Simon conducted a fairness hearing where over 70 persons gave testimony from all the walks of life. In August of 2014, Judge Michael Simon entered the settlement agreement and recorded the call for annual periodical hearings. In October of 2014, the City Council announced its intention to appeal to the Ninth Circuit the periodical annual hearings to take place. The AMA Coalition for Justice and Police Reform participated in the case of the United States of America versus the City of Portland. Restrictions to Judge Michael Simon granting the AMA Coalition enhanced amicus status. The AMA Coalition was the only grassroots voice of citizens that had direct access to the mediation and court that developed the settlement agreement, including the collaborative agreement. In the initial conception and development of the Community Oversight Advisory Board, COAB, and the Compliance Officer Community Liaison, COCO, our representatives have consistently in this period, even prior to the mediation, stressed the importance of independent oversight within the framework of the settlement agreement, even with our limitation of the enhanced amicus agreement. The independence of the COAB is called to be independent within the framework to give a proper oversight to the unique and recommendation and not to be a rubber stamp. Therefore, we recommended and push for COAB and the COCO to not be placed under existing boards and commissions of the city, but stand as a separate creating entity and providing an independent base within the framework of the settlement agreement. Although the settlement agreement gives specific roles and powers to COCO and specific roles and powers to COAB, they were designed to work as one body with different parts. COCO cannot be effective to do its work without the voices and the work of COAB, nor can the COAB do its work effectively without the administration of COCO. What was designed in the beginning conceptually had flaws and imperfections, yet it represented a framework that can be perfected as the board moved forward towards the implementation of the settlement agreement. And we want to say this. This is an experiment. Usually with decrees like this and settlement agreements, there is an administrator monitor that is appointed by the federal judge. The administrator and the monitor is the one that implement the actual settlement agreement or the decree of the judge. We, in turn, created a new model here, a model that is based upon hearing from the citizens, and the citizens in COAB giving input and insight and recommendation to COCO as to what the progress and non-progress of the settlement agreement. This is an experiment that we hope and pray that will be a model to the nation. As Ferguson, North Charleston, South Carolina, Baltimore, other cities begin to look at models of how to find a solution to the problem. It is our hope and prayer that we would not give up on COAB and that we would not give up on this settlement agreement, but that we will fix what needs to be fixed and go forward. We are at a crossroad as a nation. Portland is at a crossroad. The decisions and the commitment that you make to this effort, and you have made a lot in your time and effort, will decide the future of Portland police relations with the community for the next 30 to 40 years. Thank you very much.
Good afternoon. My name is Jonas Geisler for the United States. I'm an attorney with the Civil Rights Division of DOJ in DC. I've been asked to give a training that we're loosely calling Settlement Agreement 101. And let me give you just a basic roadmap of what we'll try to do together as a group this evening. I'd like to start out telling you what was asked of us, tell you then the background of the case so that you understand the procedure, the background of the case in whole so you understand the procedure. That begins with the announcement of an investigation, how the investigation was conducted, the findings, the resolution of those findings through a settlement, and then after our break, I would like to walk us through the settlement agreement in a paragraph by paragraph but very abbreviated manner with the goal of offering to this group suggested methodologies for independently assessing the implementation of that settlement agreement. Let me start out by saying, repeating what I said last time when I was here 2 occasions ago, first meeting. I honor the time and effort each of you are putting in. Right now, you could be at home. You could be taking care of your kids or parents or loved ones. You could be working. You could be with your parish or your community group, and you're here. That speaks volumes of you. Please join with us. Stay with us. This is a difficult experiment. It is a long process. Help us grow through this together. This evening, as I talk, I don't really want to just have a monologue. I don't want to be the only one talking. From the COAB group, and unfortunately not from the audience, from the COAB group, please interrupt me with your questions, with your suggestions. Let us discuss as we go through. And if you don't mind, since it's sort of hot in here, I'm going to take my jacket off. Is it okay?
Excuse me, was this not a town hall meeting?
This is not the formal town hall, but there are public comment periods during the session, and you are perfectly
On
welcome
the
to be
website
here.
it said town hall.
That was shifted to the next meeting for the quarterly report.
When was that shifted?
I think it was announced at the last meeting.
Yeah.
It was still on the web page.
Oh, really? No, we're sorry. There's 2 periods to talk tonight. Or 1 more period. 1 more.
Okay.
Slide number 2, please.
Oh, sorry.
All right. Does anyone know who said the police are the public and the public are the police? It's a smart guy, and he said we shouldn't police on the basis of race. We shouldn't police on the basis of privilege. And the use of force should only be used when you fail to talk somebody down. And the public confidence in police goes up, the need for force goes down. It's a guy named Robert Peel. Can you go to the next slide? He said it in 1829. These are all goals that we're working toward today, but it's not new, it's not novel. These concepts have been out there. Peel was the father of American policing. I'm sure the cops here have learned that back when they were doing their criminal justice degrees. My point of bringing him up and bringing up these concepts is that this group feels like it has a charge that is this broad. It's huge. Everything relating to policing. We have an opportunity to implement the settlement agreement that's a little bit more narrow than everything related to policing. I would encourage this group to work to be effective on what it can do right now, which is the settlement agreement. Let's figure out the methodology for assessing the implementation of the settlement agreement before we reach out more broadly to other areas. That's not to say they can't be reached, but let's do it within the charge to this group. Next slide, please. What was asked of me today? Amy sent me an email on behalf of the executive committee. The executive committee convened and asked for this training. You don't need me to read you the slide. It's up there. We'll walk through each of these provisions. I intentionally have not given you guys the slides today yet because I don't want everybody just looking down at the paper. At the end of this, however, I'm going to give Amy the slides. I have emailed them to her so that she can post them on the website, and everybody will have the slides to refer back to in the future. As we go along, I'm going to try to do take-home points. Next slide, please. Take-home points for the COAB. These are certain Accentuated points for you to use as you go forward in your work. Take home point first. We want you to succeed. We don't want to set up the COAB for failure. Your time is valuable. I do not want you to spend your time for naught. I do not want you to invest yourselves emotionally for naught. For you to succeed, I propose to you that success looks like a credible assessment that the community can fairly trust. The community can't trust it if it's not yours. Next slide, please. I was asked to describe who I was, and I think more broadly I should probably describe the DOJ team. So, again, my name is Jonas Geisler. I come from Washington, D.C. from the Civil Rights Division. Within DOJ, this huge entity of thousands of attorneys, there are several different divisions. My division, the Civil Rights Division, is charged with enforcement of certain statutes. In my section, we do police misconduct. I've been doing this I'm in my 12th year now. The statute under which we work is only 21 years old. So for the period of time that this statute's been in effect, I've been around for more than half of it. I was brought in during the last administration before all the hiring shenanigans that went on. And the few cases that were open in the last administration were ones that I opened. I've been doing it consistently the entire time. I've also been doing disability cases the entire time. I have a cross-training, if you will, in 2 different discipline areas that I bring to the table. And I offer you suggestions tonight on how to assess implementation based upon my experience going around the country doing these types of cases. There are other attorneys assigned to this case. Previously, you've met, or you may have seen in the fairness hearings, Adrienne Brown, who's from the United States Attorney's Office in Portland. She has been on this case from the beginning, just like I have. Michelle Coles is previously on this case from the beginning. She is now in a different section, but still in the division, so her resource is not lost to us. We have other attorneys assigned. Brian Bueller is in my office. David Knight was out here on temporary detail. He's back in D.C. He's still assigned to this case. In the U.S. Attorney's Office, we have the civil chief and we have the U.S. Attorney who have both been integrally involved in this case. Billy Williams has been on board on this case since the beginning. The U.S. Attorneys that have previously sat in the office here in Oregon have been involved in this case. The Assistant Attorney General for the Civil Rights Division, Tom Perez, who's now Secretary of Labor, came out here to announce the opening of the investigation. Took part in discussions with the city government, took part in the initial town hall that we had. We have back in DC what we call a police practices group. Among the 40 attorneys or so in my section, there are a number of them that are assigned to police practice cases. When we go over a case like this, we will take what we learned from this case back to the police practice group. There's a cross-pollination in which we learn how to do these cases and we teach others how to do these cases. How well we do the community oversight of a settlement agreement in this case, we'll take back to the police practices group. Ideas on how to improve things like officer accountability here, we'll take from the police practices group to here. We also retain expert consultants. In the course of our case, we retained Dr. Mark Munitz, who is one of the very few national experts on crisis intervention teams for police in the United States. He is a psychiatrist, and he has trained police. He's also a dean of a medical school in Northeast Ohio. We brought in several different police practice experts. Chuck Gruber, whom you saw at the fairness hearing. Steve Rothline, who is a chief from Miami, a deputy chief from Miami. We brought in now Charlie Reynolds, who is a longtime chief in several different police departments and is currently a monitor in Oakland and other cases. We have also consulted with our other experts along the way as we need them back in DC. We can hire more experts if we need to. We still have Charlie Reynolds and Mark Munitz under contract to work with us on this case. Special litigation section is my section in DC. The first statute I've listed up here, section 14141, is the statute under which this case is brought. 14141 gives the DOJ standing to sue on behalf of the United States, that is the right to file a complaint, against municipal and state police departments that have a pattern or practice of police misconduct. That is, it can't be an individual instance, and it's not criminal, it's civil. We sue them with the anticipation of getting an injunction. A court order that says you have to do X, Y, Z. That's what we've done in this case. Take home point for the COAB. Like you, I am confined to the lawful authority that we are permitted to exercise. Congress has permitted us to go so far and no further. There's a code of federal regulations, the CFR, which define that the AAG, the Assistant Attorney General of the Civil Rights Division, is the one who can authorize investigations and authorize settlements. Within the authority vested in our section by Congress, that's how far we can go. The same holds true for the COAB. You operate within the authority vested in the COAB by the settlement agreement, by the parties who said, yes, this is what we want to happen, and which the court said was fair, reasonable, and adequate. The investigation. On June 6, 2011, we notified the city of Portland that we would investigate the Portland Police Bureau. PPB and the city both pledged their support. And they did. They gave us the documents. They gave us free access to individuals for interviews. I don't want to give you the misimpression that any individual group is responsible for bringing DOJ to town. I can't tell you what Michelle Jones and Adrienne Brown and I said to Assistant Attorney General Perez, because that's attorney-client privileged. Suffice to say, there were calls for our investigation from several different groups. From the disability community, from the broader community, from AMAC, from individuals, even from the Adams administration at the time. I don't want to give you the misimpression that only one of those is the cause for us being here. It is collectively all of the information that we received from them and the independent fact gathering we did by reading Maxine's articles, by reading the scanner, by talking to people on the telephone, by receiving emails, that gave us the basis to make a recommendation to the Assistant Attorney General that there is sufficient ground to open an investigation. During the course of the investigation, we did interviews on the ground, several different areas, in person, out in the community, offered to go to people's homes, invited them to community centers, invited them to advocacy group offices. We went to advocacy groups and we asked them for their input, generally on what they thought and for specific incidents relating to use of force or any other allegation with respect to the police bureau. We opened up a hotline. We opened up a separate email address to collect any submissions electronically. We conducted open town halls, and some of you I know were there. Joe, we saw you there at the St. John's Town Hall. We used the expert consultants. I mentioned who they were already. In the course of an investigation for this and any other police department, you have to learn how their systems work to know what to ask. So we had to educate ourselves. You all live in as police officers. You know how your system works. We did not. We had to learn the CRC. We talked to Rochelle along the way. We had to learn the IPR. Based upon what we learned on how the system works, we knew what data to gather. The investigation of the Portland Police Bureau dovetailed with a statewide investigation that the U.S. Attorney's Office and the Civil Rights Division has with respect to the provision of mental health services in Oregon. It's a separate investigation, not under 14141. It's under the ADA. It originated as an investigation of Oregon State Hospital under CRIPA, Civil Rights for Institutionalized Persons Act. And it evolved over time into the more broad investigation. We can share information and do share information back and forth between our investigation and that. There's a separate attorney. I know some of you will speak to her, Jess Polanski, who's assigned to that case. She works with Adrienne. Adrienne also works on that case. We use the lack of mental health systems statewide as a basis for the remedies later, seeking community mental health services. After we found out what documents to request, we requested tens of thousands of pages of documents. All use of force reports for a certain period of time. All reports related to those use of force reports. Because as you know, when you have a use of force report, it has a number, but then there's an associated arrest report perhaps, or incident report, or a property seizure report. That's a large amount of data. We culled through all of that with the number of attorneys that we had assigned at the time and sent many of those to our expert consultants and had them opine upon it. At the end of the investigation, we started negotiations. My boss at the time, Jonathan Smith, who's now moved on to become an associate dean in law school, was in town along with Michelle, me, and the assistant attorney general. when we announced the end of the investigation and the finding. Right away, the city wanted to have a statement of intent that they wanted to fix things. I take that as a positive sign. Whatever judgments you have about Portland, that's fine. They're valid, they're yours. But I'll give you a frame of reference compared to other cities. I have walked into other cities and had people lie to me. I've walked into other cities and have chiefs of police lie to me. I've walked into other cities and had subordinates to the chief come around behind in the background and tell me, he's really a liar and he's covered up this and this. That's not been the case here. They have been open with the documents and they were open to do a remedy right away. I have had defendants say, pound sand, I'm not going to negotiate anything with you. That's not the case. What were our findings? We had to reach findings within the context of the U.S. Constitution and federal law. We couldn't reach findings on procedural justice, but it is not enshrined in law. We had to look for the violations of the Fourth Amendment. I will go over later, as we talk about implementation, the Fourth Amendment test of objective reasonableness for force.
Question.
Yes, ma'am.
Procedural justice, you said that you did not find. What is that?
It is a concept of perception of how one feels in response to policing. And Dennis is an expert in procedural justice and does surveys on it. Generally, my understanding of it, and Dennis can speak to it more, is that a group will go in, like Dennis's academic group, survey the community broadly, and ask them in general, how do you feel about your interactions? Sometimes the surveys are of everybody in the community. Sometimes you go into the jail because you know those people have just had an interaction recently. And you say, how was your interaction? You could, I don't know how Dennis feels about it, you could do a procedural justice on the victim side. How do I feel as a victim of a crime? Was I given a fair shake? Did you listen to me when I said I needed police help? Sure.
So you're saying that you didn't do it that way? You're
No.
messing.
The procedural justice as a concept, not enshrined in the Fourth Amendment, not enshrined in law. It's a rather new concept. Dennis could give us a specific date, I'm sure. But nothing that says in the law, you must feel good about your interaction or it's unlawful. The first finding was the use of force against people in mental health crisis. We said that while most uses of force by the DOJ reviewed were constitutional. I'm Corey. Sit right behind you. You okay if I talk about it?
Oh, yeah, sure. I'm just listening.
Most uses of force were constitutional. We found reasonable cause to believe that the PPB engages in a pattern or practice of unnecessary or unreasonable force during interactions with people who have or are perceived to have mental illness. First, the encounters between PPB officers and persons living with mental illness too frequently results in a use of force when force is unnecessary or the use of a higher level of force than necessary or appropriate. So either it should not have happened or it should not have happened to such a degree. Do we understand that finding? Is there any question on that finding? Because really fundamentally we want to understand what the findings are to understand what the remedies are. Remember, interrupt me.
Okay, what's significant?
What is?
Can you define significant? Is that more than 60%? Is that
Oh,
more than
so you want to give me a
80%?
quantitative number?
Yep.
No. And there can be a reason for that. What you don't want to do is say, in Portland it had to be 60%, in Seattle it had to be 30%. You don't want to say you'll always have to have a threshold as DOJ, that whatever town you go into, if you don't reach that threshold, then you can't reach a finding. That's not appropriate. But was there enough for a pattern or practice? And here's one of these little pieces of the case law. There's nothing in the case law out there that has tried specifically what constitutes a pattern or practice under 14141, because it hasn't been tried. Rather, we apply by analogy, where have you found patterns or practices? If I told you that a police department had 5 uses of force that were excessive, that could sound really bad. But what if there were 1,000 uses of force? What if there were only 3 uses of force that were really bad, but they were all condoned by the chief of police? And if that were the case, you could say, well, that's a practice. Because really, the chief is telling everybody, These 3 cases and anything like them is okay, so you might as well just keep on doing it. So use a rule of reasonableness. What do you think constitutes a pattern of practice? We apply a rule of reasonableness. We had a quantitative number. We had a large number of force reports we went over. And that was enough for us to find a pattern of practice. Second finding, ECW use. PPP officers use electronic control weapons, ECWs, tasers, right? In circumstances when the use is not justified or used multiple times when only a single use is justified. As the police officers have gone through the training with Warburl here, will tell you, when you use a taser, every single use has to be justified. A taser use could be contact use, it could be probes, it could be a spread where you have one probe and the contact use. Each time you pull that trigger, you're initiating a shock. Each time that's an application of force. You can't say, well, I just kept on doing it. There should be an analysis. Why did you have to do it a second time? Are there any questions on what that means? Third finding. In certain circumstances, officers use more force than necessary, given the minimum government interest at stake, or use more force than necessary given the degree of resistance offered. So government interest, minimum resistance offered. Let's go with what this means. If I use force as a police officer, I must be objectively reasonable in my use of force. If the government interest is high because there's a bank robbery, there's a need or use for greater use of force. If the government interest is low because a person is walking across the street, how many of you read our Ferguson report? Walking in the roadway, right? Was in our report? If the government interest is low, why do you need to engage in use of force? The government interest may go up if somebody's walking in the roadway and then turns and strikes somebody else. But if the government interest is low, so too should the force be low. The degree of resistance offered. If I merely sit down, I'm being passively resistant. Passive resistance is different than actively taking a swing at somebody. I think you would agree with me that if an individual takes a swing at somebody, takes an active swing, that anybody else may step back and try to defend themselves. Is there a question about too much force for low resistance or low government interest? Yes, sir.
More like a comment. And correct me if I'm wrong. In order to reduce use of force and violent force and essentially to have people not lose their lives, we introduced the beanbag. Then when that didn't work, we brought in the taser. So it seems like we shouldn't have to recreate another way to have officers use deadly force. And it was more of a comment just to say, like, I understand the one-to-one agreement, but it seems like or it seems like there has been just a little Band-Aid. Like, okay, we have the beanbags. Okay, that didn't work. Okay, let's try the tasers. And now we're going to use cameras. Like, what is next? In order, how do you not, and I made this comment earlier to someone else, like, we shouldn't be responsible for teaching officers or teachers or whomever to be compassionate, loving, and caring, and not biased, and not being sexist, and not perpetuating patriarchy. Those are things that we are all innately equipped with. So from my perspective and some other perspectives that I've gathered along the way, it just seems like we shouldn't have to re-educate folks how to be human beings. And although we are grateful for the city and the Portland Police Bureau and all bureaus across the country trying to reduce use of violent force, it just seems like after this doesn't work, then what else are we going to try next?
I hear you, Manuel. That's it's a broader question, right? Organizations mature. I stuck with the Tennessee case for 26 years, right? I was not the first guy on it, okay? So I had the last 12 years. The organization was terrible at the beginning. The judge found it was a culture of death. It's the findings of fact, culture of death. It was a healthcare case. But it matures over time. Working together, the organization, the police bureau, has already changed in the time we've been here. The organization will continue to mature and adapt as this society changes. There's no doubt that this is not going to be the last thing that happens. This is not going to be the end. But that arc of change is long, as is the memory of the past. Working together right now, let's try to implement at least these provisions. Maybe there'll be a little bit more humanity and a little less concern for which weapon one chooses. In addition, I'm sorry, Bud.
Would you say then that if we are successful at the end of this process, that if we were to look back at the individual cases that DOJ reviewed for those findings, and we were to review those against new police procedure, that we would find that we should be expecting minimal use of force and better outcomes? Is that a valid test for the work that we do?
So, Bud, my understanding of your question is, would we look back at the last set of data on which we based our findings and find today would we use less or minimal, we, the PPB, use less or minimal force? Yes. Optimally, we should find that. Let me give you an example, okay? Orange County, Florida. Orange County Sheriff's Office. Anybody know Kissimmee? Orlando? Eric? All right. Orlando, the outlying area, it's a very large county. Orlando City Police not involved, but the Sheriff's Office had an agreement with us about taser use. So we learned about taser use there, and we said there's a problem, and we entered into a side agreement. There's a small agreement with them. But we said we're going to stick it out and make sure that training's right, make sure uses of force are right for as long as it takes. And we did. It took several years. They went from 300 taser uses in that department per year to 30 per year. 300 to 30. The use of other tools, like a PR-24 or an ASP or a gun, did not go up. Injuries to officers did not go up. De-escalation can occur. Monitoring, watching the use of force reports, having an assessment of those use of force reports internally, that has an effect. It drives down uses of force. Yes, sir.
So you consider that a cultural change within the Bureau based on that you were monitoring it and you've seen it go down? Did it actually change the culture and mindset of officers with the community members?
Yes. There was a new leader who came in, Sheriff Dennings, down there, and he said, this is the way it's going to be. And they had to follow suit. And they brought in trainers, and they trained people, and they required people to do training. And then they did audits of use of force reports, and accountability occurs. Culture change. Let me move on the findings letter. The findings letter, we're just on this part. I'm going to keep on moving at a good clip here. I like the discussion now. In addition to constitutional findings, we made the city aware of systemic issues that we thought contributed to the constitutional findings. Mental health specialization. There was a need for a specialized response. There was a decision in the Portland Police Bureau to have everybody trained at a veneer level in crisis intervention. And that can be useful, but you want specialized people who are really interested in it to dig in and get called out whenever they can to a call that involves a person with an actual perceived mental health crisis. Or you call out the mental health worker with the cop. And that occurred on a smaller level here with the Project Respond, but they had one car at the time, and 2 cars at the time. The second systemic issue was supervision of force. You've seen in the finding, sure.
I'm sorry, can you go back to that slide that was up there in regards to mental health specialization? Did the Department of Justice, why didn't you not include the county in your investigation, seeing that they are responsible for human services and mental health?
Right, good question. Why didn't we include the county? Because we can only do what we're lawfully allowed to do. 14141 says, you DOJ may investigate law enforcement agencies for violations of constitutional or federal statutory rights. That's where we could reach. We couldn't reach the county. However, recall the other point, the dovetail. Dovetail with a statewide mental health case. That's ongoing right now. It hasn't stopped.
So the county is included in that?
It's a statewide case in Oregon, and I don't profess to be the expert on it, okay? But in Oregon, your dollars flow from the Department of Health to the county to use for mental health services. Supervision of force, second systemic issue. We found it lacking. PPB, almost right away, implemented Directive 940 to have sergeants go on scene to do on-scene investigations. Supervision was lacking, therefore there was not accountability in force. There was remediation almost from the get-go. I've heard criticisms that DOJ didn't get immediate action. Okay, I'll take that. But on certain things, there was change, and change was for the better. 940s began to occur. Third systemic issue, corrective action. We found that the corrective action system, and with all due respect to Dr. Silver, that CRC and IPR that everybody spent so much time in, it's such a long process, right? The corrective action needs to be more prompt, consistent, and everybody needs to have a reasonable expectation from the complainants to the officers on what the outcome should be. Findings on every case, discipline instilled on a consistent basis when there is a basis for it. We'll get to that in the remedies too. Additional community concerns. These were things the community expressed to us that were not constitutional findings, but we still expressed them to the city, and we'll get to in the settlement agreement where they came to fruition for remedies. Access to medical care and community policing. Police, you need to be tuned in to the community. I think they know that. I think they do community groups. They do town halls. You need to get medical care. A lot of the use of force reports we saw, the medical care wasn't prompt. You need to establish the guidelines on who can take out taser probes and when EMS clears somebody to go to the jail. You need to get the EMS on the scene. These are part of the remedies that we'll talk about. Context of the findings. It is unfair. Unfair, right? Portland has more X, Portland's different. I get that. Our findings take place against the backdrop of a deficient community mental health structure. Sharon, as you said, right? It's the county. It's unfair to the police bureau because they're the first responders. And they don't have control over who's going to live in their community. But tough. You don't get to decide who lives in your community because we're a free society. So as unfair as it may be, the first responders have to live within that context. We did not deem the city, the police bureau, or its members individually liable. We didn't say, you, Officer Meyer, are the one who's responsible for this and we're going to sue you. It's a pattern or practice investigation. It was the city who's the defendant. And the nomenclature of the law, it's the city's the juridical entity. They're the ones who get sued, not the police bureau. We did not reach any additional constitutional findings. I know there was a call for a finding on racial profiling. We looked at data. We did not find sufficient data to support a finding of racial profiling. There's a different test for that. I'll give you the test. One second. So test is disparate impact and disparate intent. It's tough, but we didn't reach the constitutional finding on that. Go ahead, Sharon.
So when you say under racial profiling, as far as impact and intent, why was that? I mean, seeing that when you have a overproportionate of communities of color who are being really overbearing, populating the jails and the prisons. If you look at the annual reports and you see that from 1980 to 2013, 1,058 African Americans were murdered right in Northeast Portland. To me, that would seem like definitely adverse impact and intent on a small community with numbers compared to the overall city. And so to not find anything is very hard to understand.
I hear you, and it's your opinion. Your opinion's valid. Let me take one more. I'll try to answer because I think it's going to be related. Go ahead.
Sure, and if you don't mind if I sort of...
Sure.
The issue that I have with that, it for me, right, is a proportionality. Certainly, African American, I'm from Portland, Oregon. African Americans are some 6-7% of the population. And so I'm not sure how it is that, I'm not trying to attack you obviously, but I'm just trying to understand how that came to be when the proportion just seems, pardon the nomenclature, so out of whack.
I hear you. Okay. A couple of things. One is I can't tell you the attorney work product, the deliberative process that we go through internally. Right? It's subject to privilege. But me and the other people that I work with in DC and the people here in Portland working on this case, we want to find what the facts will support. We want to remedy violations of law. You don't do this type of work because you want to try to cover it up. You don't invest yourself in extra hours because you think, oh, I can shove this one to the side. If it were attainable, I would attain it. I can't attain it. The Assistant Attorney General for the Civil Rights Division and the U.S. Attorney have to approve the findings. We have to have factual basis for the findings. We have to be able to defend them in court. And in court, it is difficult to prove discriminatory intent and discriminatory effect. I'm not saying your opinion is not valid. I get it. I don't walk in your shoes. You live here and I don't. I'm just saying we could not find the evidence to support the finding. We didn't reach the finding. It doesn't mean that it doesn't matter. It doesn't mean that the remedies here don't help and affect that. Take this to heart. The rising tide lifts all ships. If you improve the accountability systems for uses of force in general, you should improve the accountability systems for allegations of racial profiling, and you should improve the accountability systems when somebody says, they didn't investigate my use of force complaint because I'm African American. That doesn't cut it. The accountability system should be so well put together, so trusted, that all of those sorts of allegations would be addressed, accountability in general with supervision improved, and the net effect of that is that in 5 or 10 years down the road, the organization is more mature, has earned the respect and trust of the community, and there is less need for force. There are fewer allegations of racial profiling because, in fact, less of that should occur. It may not be a finding, it may not be a specific remedy for, quote, racial profiling, but there's community engagement in the settlement agreement. There are improved systems in the settlement agreement, and all of those raise the boat. What happened after the findings letter? I'm sorry, Phil.
Yeah, no problem. So I want to know a little bit more about the use of force, the systemic use of force, and I had a question relating to that. From my experience and my perspective, use of force is not just it relates to police attitudes and their perspective about mental health and language barriers and disabilities, and all of those rolled into one, that diversity, understanding of diversity. Because we have a lack of understanding about diverse cultures here and about mental health issues. So I'm just wondering what your findings and trainings will be for that lack, in which will apply to excessive use of force.
I hear you. I agree that attitudes affect uses of force. In order to reach a constitutional finding on force under the Fourth Amendment, there has to be an actual seizure. The seizure is the application of force. The apprehension or fear of application of force is not sufficient. So for the ones that we reached findings on, those were based upon actual applications rather than the mere attitude of I'm going to hassle you because of who you are and how I perceive you. Going forward, this group is going to help shape the CEO plan. This group is going to help assess the implementation of the remedies that would include the Training Advisory Committee, the Behavioral Health Unit Advisory Committee, and plug in what you learn to the training on a constant quality improvement loop. You create a policy, you teach. Sorry.
Well, I ask you this because I have an example in mind. It's another community experience that I've had. But I just really want to emphasize there are 13 deaf individuals in jail right now in Gresham, and they don't have any video phone access, there's no access to interpreters, no communication access at all. So when they're under arrest, was their arrest legal? That's, I guess, my concern, and that's just one example of the overall picture. So that's kind of why I asked that question.
Well, thank you. I can't opine as to whether or not their arrests were legal. I would invite you to speak with me. I need to get on a plane later tonight, but please call me. Within DOJ and the Civil Rights Division, there is a separate office called Disability Rights Section that can handle individual complaints of ADA violations and can handle individual complaints with respect to the lack of accommodation. I'd be interested to know what they have to say about the video phones in Gresham.
Okay, yeah, and I am working on addressing that issue. But I'll contact you. Thank you.
Senator Gorley.
Thank you, Jonas. Going back to the issue of racial profiling just for a moment.
Yes, ma'am.
I did not hear you say what I thought you were going to say, which is that with regard to there being no finding around racial profiling, that was as a result of deficient data keeping.
So, good point, Senator Gordley. You'll see in the remedies our encouragement to the PPB and the community to create the data necessary to find out whether or not racial profiling can be evidenced. There will be many other cities that want our attention going forward, but whether it's DOJ or a private plaintiff's attorney, and I understand there's a few in Portland, right? If the data are kept by the police bureau on race and gender, on age or disability, on language proficiency, one should be able to understand going forward whether or not one can evidence racial profiling or disability discrimination or LEP discrimination. So while the settlement agreement may not give you the panacea of cures to all the ills that we perceive in society, hopefully it will give you an additional tool as a group and as a community to address that issue going forward. If I may, because I want to keep on moving here, the settlement agreement. After we reached the finding, we had to get to a resolution. There's a settlement privilege. That means when two parties go into a meeting to try to discuss settlement, you don't go outside of that meeting afterward and say, these are all the things that we discussed. If you did that, you would destroy all future settlements. So the Ninth Circuit, which is the federal circuit over this area, has acknowledged that there is a settlement privilege. That means we are not supposed to talk about our settlement negotiations. That helps future settlements for all sorts of cases. So we don't say, the city offered this, we offered that, and here's where we came to. Rather, you see the findings and you see the result. The settlement agreement is the result. It should be self-evident in the settlement agreement. This is what both parties would agree to. In the process of doing the settlement negotiations and the agreement, we solicited stakeholder input in Portland. We didn't wait till the end. Just as we did with the investigation, we went out and we asked everybody, what do you want to see as a remedy? On October 24, 2012, we released the settlement agreement. The city had city council hearings. We had telephonic town halls. We had direct communication face-to-face with advocacy groups. We took public comments, made revisions. On December 17, 2012, we issued the final settlement agreement. We weren't going to get into years-long revisions. We heard the comments. We negotiated what we could. We made the changes that we could. On December 17th, final settlement agreement is filed in the U.S. District Court with our complaint. Next slide, please. The U.S. complaint is based on and limited to our findings. Our jurisdiction under the law is you can only sue where you have a finding. You can only have a finding if it is a violation of law. You only have standing to sue under 14141 if it is a violation of law. We sought an injunction, that is a court order to require change. We attached to our complaint and moved jointly with the city, that is both the city of the United States said, court, please approve this, a settlement agreement, the one that you have before you, to remedy the findings. But what happened after the U.S. filed the lawsuit? Next slide, please. Well, we filed December. Very shortly thereafter, next slide, the PPA intervenes. The PPA is the Portland Police Association. There are two unions in Portland, commanders and police. The PPA, the general union. The PPA is the only one that moved to intervene. PPCOA did not. The PPA said that we infringed upon their collective bargaining agreement. That is their contract between the union members and the city. Ultimately, we resolved this. We'll get to that. One of the important take-home points for you, the PPA is not the monitor. They don't get to say compliance or non-compliance. Next slide. AMAC. AMAC moved to intervene. The court said no. Intervene is a legal term of art. It means I want to be a party to this lawsuit. It means I want to be listed when it says United States versus City of Portland. I want to be listed United States and AMAC versus City of Portland and PPA. The court said no. AMAC is not a party, but the court made them an enhanced amicus curiae. Amicus curiae is the Latin term for friend of the court. You'll see stories in the newspaper about Supreme Court and somebody files an amicus brief. Amicus is a friend brief because that friend has something they want to say. Enhanced amicus is an invention of Judge Simon's decision. It's fine. He gave them the ability to sit with the other parties in the well of the courtroom, that is at one of the tables, and to participate in the hearings. AMAC can't appeal. They can't enforce on their own. AMAC, however, is treated as a party. They have counsel. They're there before the judge. AMAC, however, is not a monitor. Next slide, please. What did we do? Well, they moved to intervene. The court said yes, PPA. The court said no to AMAC. But the court generally was upset with the concept that everybody could not agree on the settlement agreement. The court sent us to mediation. And just like settlement, there's a mediation privilege. Mediation is you meet behind closed doors and try to work out your differences so you don't engage in really lengthy, expensive litigation. We met behind closed doors. Can't say what happened, but again, the outcomes are apparent. Next slide. The PPA, the city and the United States entered into a side agreement. It's filed with the court. You can see it. If you need copies of it, we can give you the copies. The PPA waived its objections to the settlement agreement for everything that they said was foreseeable, but they reserved their right to grieve. That is, if you're a union member, many of you may be, you can grieve things that happen to you, like discipline or hours you have to work. So they reserve the right to grieve certain provisions of the settlement agreement, like the 48-hour rule, like the disciplinary matrix. So we can all come together and say, this is what we want to happen on the settlement agreement, but we still may have to go through an additional hurdle of a PPA grievance. That may come to pass. That doesn't mean it's not going to come to fruition as a resolution. It just may mean there's an additional step and a lengthy step to go through. The AMAC, the city, and the United States entered a separate side agreement. In that side agreement, the AMAC said that they would continue to assess implementation on their own. They would opine upon it. They also got the very specific remedy of being able to change the appointment of the COAB. Your appointment then included all of the work of the AMAC. And we're indebted to you. Thank you for all the additional work that you had to do to participate in that process. Here's the take home. The COAB does not have an active role in the execution of the PPA or the AMAC side agreement. You can be concerned with those. You can look at them. You don't do an assessment of whether or not they're being complied with or not. There's enough to do without that. Next slide. So after their objections were resolved, what happened? The court held a fairness hearing in February of 2014. The court reached a finding at the end of 2 long days of very contested testimony. The settlement agreement is substantively fair, reasonable, and adequate. That's a legal test. But the court said that he wanted an additional procedure. Back to mediation. Next slide. Send all 4 parties to mediation. I'm referring to AMAC as a party because the court said refer to him as a party. What's the result? Disagreement's the result. We didn't resolve it. Instead, we each filed briefs with the court. We presented different plans. We said, court, please accept one of these other plans. Didn't work. In the end, the United States and the AMAC said, court, there's a contract between the city and the United States, but if you as the court who's supervising this order want to have a status conference, that is appearance in court to talk about it, you may do so. The city and the PPA filed a brief that said, you cannot impose any additional conditions on that contract. Makes sense, right? You say, we have a contract to sell a car between us. You can't say now, oh, but you have to upgrade the stereo before you give it to me. All right. 1 second. That disagreement doesn't mean that we can't ultimately reach resolution. So the judge entered an order. Go ahead, Sharon.
Well, I just had a question back when it said that AMAC actually waived its ability to object to that. So at this point, they were coming back to say, we want to be able to have this conference if need be, if the city is not following the agreement. Is that what that was?
I would let the AMAC speak for themselves, but I would encourage them to do that at the time when we're at the end. I'll characterize it this way. AMAC said, we reserve the right to continue to work upon police reform well beyond this settlement agreement. Makes sense. They're a long existing community group. They should be. But we support the entry of the settlement agreement. In supporting a status conference, they supported the entry of the settlement agreement, but they also wanted status conferences. Court enters an order. But
I just want to make sure I understood that correctly. So you're saying that the United States and AMAC wanted to have Judge Simon having status conferences of some sort, but the city and PPA wanted none. Is that what I'm understanding you to say?
that's in their file briefs.
Okay.
Sorry.
I do have to stand up. So I'm the attorney for the city. That is not correct. The city's position was that, in fact, we supported status conferences. The conflict was over what the status conferences would look like. And so early on, the AMAC and the PPA and the United States and the city all went to Judge Simon and said, this is what we want the status conferences to look like. And Judge Simon said that he did not like our initial proposal. So all 4 parties went back, we talked some more, and the 3 parties, the United States, the city, and the PPA came up with another process that we thought would work, how we wanted to see the status conferences. The AMAC did not agree with the proposal of the other 3 parties, so we went back to Judge Simon, explained that 3 of us were in agreement, 1 was not in agreement, and then Judge Simon issued his order. But the city never, in any of its filings, said that we would not appear at a status conference. We did, however, have a disagreement with both the United States and the AMA over what the authority of the judge was to impose conditions to which we did not consent. So that was the legal disagreement. The AMA in the United States, their position was that the judge could impose conditions that the city didn't agree to, and our position was that we had to agree to what the status conferences would look like. So that's the distinction.
I accept Alan's correction, and I want to make sure that we speed up as we are already about 20 minutes behind. August 29th, the court orders, yes, settlement agreement, but you have to have evidentiary hearings. So it's another step even beyond status conferences. The city appealed the authority of the district court to order additional evidentiary hearings. There's confidential mediation ongoing. Against mediation, confidential. Hopefully it works. If it doesn't, appeals in the 9th Circuit are running about 1 year right now. Take home point. There has already been a significant delay. That doesn't mean PPP hasn't been doing stuff. Like I said, the 940s, right? It's already ongoing. But there's already been a significant delay. let us make our time together valuable and productive. Second half is going to be implementation. We'll get to it after the break.
Yes. Like, everyone's getting an Amber Alert right now. It's what all the buzzing is about. Ellen, did you have any additional comments to make?
I don't. Since we are running behind, several COAB members had asked me to speak about the appeal, and I sort of just gave my 2 cents, but I'm very happy to have individual conversations over the break or afterwards with people so that I don't continue to delay.
May I ask also that our lawyer for the coalition is here. She can also speak about the appeal too.
And then we, just before the break, we're going to hear from Bob Jundev. Like to come up?
Well, everything you said was important, but in the beginning, you made a reference to 1829 and a John Aaron or something, and what he said. I didn't really get a chance to write that down. Or could you reiterate that possibly?
Yeah. Robert Peel.
Robert Peel. I was way off.
Robert Peel, look at the Wikipedia page. You'll see the 13 points of policing. It'll blow your mind that we've been doing this for over 100 years, and we're talking about the same stuff.
That doesn't blow my mind.
Yes, point of order. Yes, go ahead. No?
Please clarify when we will hear from the AMA attorney on the point of the appeal. The settlement is getting ready to shift to another conversation with Bob Jundev.
Okay.
The other conversation.
Is there anything that's... Oh, you want to talk from Ellen, you mean?
Do you have a question?
I don't have a question, but Dr. Haynes said that.
Well, let's stay focused on this issue before we move to mental health.
It is about this issue.
And well, she still has the floor. So
I'm sorry, Ava.
Eval, you're asking if the attorney associated with the AMA would make a couple comments briefly.
Yeah, what we want to get be able to understand about this appeal process that we believe that there was some deception in the process by the city government in the appeal process of first saying that they wanted only to look at the issue of procedure, but their initial petition to the Ninth Circuit Court was over the question over the authority of the appeal.
I can explain it. So what Dr. Haynes is referring to is
Just stand up, Mike, let's further back.
what Dr. Haynes is referring to is a questionnaire that the city filled out, that they were required to fill out by the court. It was a mediation questionnaire, but it wasn't confidential because it wasn't actual mediation. And that questionnaire challenged the court's authority to order any additional proceedings. And so the city's position there was the court can't do anything, not status conferences, not anything. It had no authority to do anything additional to what was in the settlement agreement. And Ellen has explained now that I think what they intended was to put some parameters around that status conference. And I think it's worth explaining the difference between an evidentiary hearing and a status conference. So an evidentiary hearing is a much broader, it's an inquiry. People can take the stand to be, evidence is introduced. So documents are presented, witnesses take the stand. A status conference is a much more informal proceeding. Parties and their counsel appear before the judge, and generally they tell the judge what the status. It's no evidence is presented at that kind of proceeding. And so that was the distinction that Jonas was making. An evidentiary hearing is a much bigger thing for the court to order that than to merely order status conferences. And our position, the AMA's position, in its briefing with the court was that status, of course you can order status conferences, but we didn't take a position with regard to evidentiary hearings.
Okay, thank you. Let's move on to the final presentation here, representing mental health, and then we'll take a break.
Hi, everybody. My name is Bob Jundev. I'm the Director of Disability Rights Oregon. How you doing? It's hot. It's nicer outside. Listen, I want to not take up too much of your time, but I want to tell you why I'm here and why I've been asked to speak. I got an email saying that, asking me to share the mental health community's perspective on the settlement agreement and the COAB's role and what success would look like. So what I did, and I'm the director of a nonprofit organization that gets funded to advocate on behalf of people with disabilities. I've been at it for about 30 years. I've been a public defender. I've been a legal aid lawyer. I've done civil rights litigation. So I've kind of been around a block a little bit. So I took that question and I sent it out to a number of people who are folks in the mental health community, or at least what I perceive to be the mental health community. When I say that community, I say people who receive mental health services, who may have received mental health services and don't anymore because either they don't need them or they were unhappy with them, family members, and professionals who work in that world. And the first response was, why were you asked, Mr. Jundev? You do not have a mental illness. You have not had it run in with the police in which you have been subject to force. Why did they ask you? Why are you the person who is here to speak for the mental health community? I didn't answer that. I thought I would just pose the question back here. But what I can tell you, having worked in this world for as long as I have, is that people with mental illness are highly defranchised in society. They're stigmatized. Their voice is not heard. I still go to tables in the mental health system at the state, at local level, after passage of a law that says there's a certain percentage of people with mental health issues need to be at those tables to discuss policy issues, and those people are not there. So this is a voice that is not heard. Because this voice is not heard, it is not understood, and frankly, it is feared by people who don't understand it. And so this creates an enormous barrier to communication. I completely, personally support the work that has been done so far. I know this is a huge lift, but this is something that we absolutely must take into account, and I'm here to bring that message to you. So I'm just going to tick off a few of the things that people said so that their voice can be heard. I'm not endorsing or not endorsing what those statements are, but I will take them to you. From a clinician, intense police training on mental health issues and de-escalation strategies have to be a result of coming out of this process. Boosting the behavioral health unit caseload needs to be an outcome of this process. Thoughtful use of body cameras. In other words, thoughtful being use of those cameras that is helpful and not a violation of people's rights. And absolutely more outpatient mental health and addiction resources, including supported housing. And the thing that I will talk about right at the end, quickly, is that I think this is an absolute key to our success. An advocate responded to my question about what would be successful. That advocate said that I do not represent, that meaning me, Bob Jundev, do not represent the thoughts and input of a person with mental illness who's been subjected to undue force, that those individuals are missing and unrepresented on the COCL and COAB, and that the COCL and COAB are intentionally setting off in the wrong direction to not solve the real problems. And this advocate would want to stop the process. I received a message from an individual with lived experience who responded that success would include a demonstration of how a group of diverse people, including the, quote, normal public, peers, police, and others can come together and learn from each other and become an active and dynamic group and question each other without personalities and agendas getting in the way in order to get beyond their personal pain and misunderstandings that they've experienced in this system. Another note of success would be that the COAB instructs the community, is a teacher of the community in how to be empowered in the public processes. So how people can engage in these processes and not feel that they are excluded from them. This person felt that the community's voice, the affected community's voice, is not at the table. And in order to do that, the COAB must support effective communication with the mental health community. And hopefully today is part of that process of learning how to be effective communicators and to recognize the complexities of the problems, but not forget that the core of this agreement was about mental health services and mental response to people with mental illness, even though that is a shared experience among disempowered populations. Lastly, on that score, that if the COAB is able to promote mental health awareness, to fight stigma, and to have a it's not me, I'm just reading the words. And to have a process that is solution-oriented, word-conscious, and celebrates successes. It will be successful. This from another individual with lived experience. Success would include integrated treatment systems that emphasize dual diagnosis of mental illness and substance abuse, community-based mental health substance abuse delivery systems that include peer support as a component, and services that are available when needed. My personal view is that I've been doing advocacy a long time. It takes time. It takes trust building. That takes time. And it takes what I like to call the slow squeeze, which means that you have to be there over time, and you have to be persistent, you have to be consistent, you have to keep at it. And when you do, you have power. Disability Rights Oregon is part of the Albina Ministries Coalition. We have been all along because we recognize the power of coalition. We recognize that groups of people need to come together. People who've experienced the same disempowerment and victimization need to work together, because alone we do not rise, we hang. And so we have supported working together on these issues, and there's a lot of things to be angry about, and there's a lot of things about this process to grumble about. But the fact of the matter is that we have a room full of people who care about this and want to do something, and that's something that we did not have before. And so my second point is, or feeling about this, that I've learned over years of doing this is a quote from Buckminster Fuller, if anybody knows who that is. And he said, "Don't fight forces, use them. Recognize your power." And this is power. These are resources. These are thoughtful people. These are people with experience. Use all that, because that can and will be effective. And so I'm very hopeful about this process as a member of the mental health community, although I'm not the right spokesman. And I feel that you all really do have the power, and as soon as we can realize that together, we will be effective. So thank you.
Okay, we're going to take a short break, less than 10 minutes if we can, and then you have questions about the presentation? Okay, let's spend 2 minutes on that. 1 minute. V, you're up first, and then Avel.
Thank you for coming. Would you be willing to submit your cheat sheet there, so that way it can go on the website and be available for others, please?
I anticipated your question because I left my folder up there.
Awesome. Thank you. Thank you.
And we're going to stop.
Oh, thank you.
I think it's important that you say just a few words about the dovetailing
between this work, the COAB work, and the statewide mental health investigation that the Department of Justice is also involved in, so that we all have the best understanding possible of where that comes together.
Yeah. Thank you, Senator Gordley. Are people familiar with the Americans with Disabilities Act?
Yes.
Very good. There was a legal case about 15 years ago now, which we call the Olmstead case. And what that did is it said that, you know, part of the ADA, like other civil rights laws, say that it's illegal to segregate people with disabilities. And segregating people with disabilities means that you take people, for example, with experience of mental illness, and you say, if the government is going to give you services, you all have to go into one big building and go into that building and be looked after by non-disabled staff and sort of live in a camp environment where you get that. What the ADA says in that case is that people have a right to receive their mental health services, government-funded services, in the most integrated setting available, which means in the community. So, if a government like the state of Oregon that has a pot of money to spend on mental health services says we're going to put most of our services into our state hospitals and shortchange our community mental health system, that violates that law. So there was a complaint to the U.S. Department of Justice and an investigation of that claim that the state of Oregon, as a matter of policy, was illegally spending its money on mental health services by putting the majority into these state hospitals and shortchanging the community. That's what the complaint is about. There's been years of negotiation and a settlement. It's not actually a settlement, but it's been a negotiated process by which the state has essentially promised to put more resources into the community. And what that means when it comes to police is that instead of a person not being able to get mental health services, experiencing a crisis, having the first contact be a police officer, takes that person to jail or to an emergency room and has them committed, this is a structure that forces people into avoidable and unnecessary segregation. And the only way to combat that is to make sure that there's adequate community mental health system services, that there's good crisis services, in other words, that there's mental health personnel to respond to those services. There's a way to divert people from jail who don't need to be there and to get them the supports and housing that they need so that they can remain in the community and get better. And then avoid having that happen again. So that's what this case is about. The key to it is that the state steps up and funds those services. And that's what we're fighting about in the legislature now, and is making sure that the money is there, and your voice is needed for that, because it doesn't happen unless the public wants it to happen.
Thank you. All right, we'll take a break now and we'll come back soon. Thank you.
One of the specific questions asked to me by the steering committee was, well, what's the relation between COAB and IPR and CRC? Take home point. This group, the COAB, does not replace the CRC or IPR. Recall that IPR not only does investigations, but also can do systemic analyses of the police bureau and their systems. That's beyond the call of this group. Let us not take down the structure that's already in place in this city for corrective actions and analysis and self-thought that exists. That will stay in existence. Yeah, this microphone's only going to slow me down. All right. Settlement agreement paragraph 141 gives the COAB 6 major functions. So the question always is, right, what is COAB's job? COAB's job is in paragraph 141. First and most important, A, independently assess, not monitor, independently assess implementation. The United States is the monitor of the agreement. We need your independent assessment to contribute to our monitoring. 2, make recommendations. 3, advise the chief and commissioner. D, provide community with information. This right here is the provision of information to the community, as is your online portal. E, contribute to the development of the CEO plan, Community Engagement Outreach Plan. And F, receive public comments and concerns. Every time you meet, you need to receive public comments and concerns. Let me submit to you that the 2 most definitive roles you have are A, the assessment, and E, the CEO plan. I do not want to rehash what we've already gone over in the DOJ memo about the COAB and COCO relationship. In order to speed things up, let us take the next slide. Paragraph 144 describes the relationship between the COAB and the COCO. We do not need to ponder on this, but please reflect upon that memorandum. We are sure that that memorandum is correct, that the COCO will chair the COAB. And one specific point, alternates can sit on committees. Alternates cannot sit on the steering committee as a member. Alternates cannot chair subcommittees. Do not hash over this ground again. I think we have buy-in from most everybody on this. Any alternate that's serving as a chair of a subcommittee right now needs to step aside on that role. And I know Tom Steenson, smart guy, we like the guy, right? He's gonna have to step aside from chairing his committee. If he becomes a COAB member, and since he's an alternate that is pretty highly placed, I think he probably will matriculate up to a COAB member. At that point in time, he can chair a subcommittee, but not until then. The reason is we do not devolve the authority of the COAB to non-COAB members. The authority remains with COAB members. We will spend no more time on this. The issue's done.
Question, just a quick clarification question.
Yes, ma'am.
He can sit though on the subcommittee, right?
He may sit on the subcommittee. He may not chair the subcommittee.
Okay, I just want to be clear.
Paragraph 151, this is crucial for everything that this group does going forward. When there are recommendations on behalf of the COAB, recommendations must be subject to a vote. Not just a vote of who's present or a quorum, but it actually says in the settlement agreement, a majority of COAB voting members. Take home point, voting COAB members, not alternates or advisory members, vote on recommendations. Paragraph 152. The COAB must allow public comment. You guys do this. This is pretty straightforward. Paragraph 163, this is important for tonight. The COCO presents a quarterly report. That means there's an... Okay. I'm on paragraph 163, which is the next slide. Is that okay? Paragraph 163, the COCO presents a quarterly report. There are 90-day windows, right? Is that right? COAB presents a report. We, the United States, the city, and the COAB have 30 days to comment on a COCO report. COCO then needs to finalize it and give that report, as we've planned, I believe, thus far, and what we've said to the court, give it to the court, right? Give it to the public, too. We have to be expeditious. We have to be public. We have to be transparent. When Dennis gives that quarterly report, it is the responsibility of both the COCO and the COAB to widely publicize the town hall meeting at which discussion will be taken about that report. May 28th is the public discussion. Please tell all of your community groups, of which you are part, that May 28th is the public discussion about the COCO quarterly report. Sure.
So that report was released today to us and to the public, correct? So this today starts the 30-day period.
Correct.
And then we requested to have the same list that Judge Dominguez had of all the community groups so that we can make sure all the community groups are getting it. But also, we wanted to make sure, because many people have moved to outlying areas, that the information be disseminated to like Beaverton, Tiger, Vancouver, Gresham, because a lot of people have moved within the last 5 to 10 years who have been impacted and affected and would like to be able to participate, but because they don't know about it, because the information is not being disseminated outlying Portland, then they don't get the information. So that is something from the COAB we would like to see happen.
For each of the material provisions of the settlement agreement, I will suggest to you an implementation methodology. Likewise, for this one, may I suggest to the COAB an implementation methodology. Under the settlement agreement, the city provides administrative support to the COAB. All of you, and I've said it before, you have friends, families, jobs, things to do outside of this room.
Yeah, we do.
The city, they have important jobs too. There's no doubt they're important. They have many things to do. Their plate is full. But let us say, tell the COCO that you want this publicized through the city. Tell the city then, use your press office. You have a press officer. You have the means to post this on your website. You have the means to push it to the media, and including the surrounding areas. Use those tools. The tools are already existent. Don't reinvent the wheel.
Okay, thank you.
Mr. Price.
Just quickly, could you clarify, if you could or would, what administrative support is to the for the COAB? Is that we have access to computers, we have access to print materials, we have access to phone calls and maps and things of that nature? Just so I know and other folks know what exactly that means. Or if somebody else could answer that, possibly.
A rule of reasonableness, I think, should apply here. It is not defined exclusively in the settlement agreement. You should have the COCO office. We would like to see you get the support to have a computer or two there for all the COAB members who don't have computers to get access to documents online. Administrative support may also mean the provision of documents to you when you request the documents. It may be a secure way of getting those documents so that you can preserve confidentiality. The CRC already has a methodology set up right now to get documents. Something along those lines might be appropriate. Administrative support, use a rule of reasonableness. Does it make sense?
I didn't catch that last part, I'm sorry.
To use a rule of reasonableness. Should you have a reasonable expectation as a COAB member that if I need a copy of a document, the city's going to give it to me? Yes, on a timely basis. Not immediately, but timely. There are substantive provisions of the settlement agreement, and this is the meat of tonight's presentation. For each of these substantive provisions, I'm going to very quickly walk through the paragraphs, and I'm going to suggest to you a methodology by which you may do 141A, independently assess implementation. Take home point. There is currently an effective date on this agreement. The effective date is the date of the entry of the order. That may change if we get a new order entered. We may agree to reflect upon the prior effective date. You have heard about what brought DOJ here. You know the context of history. You cannot assess implementation from before the effective date. You cannot say the city's out of compliance for something they did before it was unlawful or against the agreement for them to do it. So as of the effective date, look at those use of force reports going forward. You look at those sit-rep reports from the BHU. Don't go back 10 years and say this that you did 10 years ago justifies a finding of noncompliance right now.
February of 2014.
August 29th, 2014. Use of force. This is the biggest area, right? I'm sorry, doctor. Use of force. This is the biggest area in the findings. I want to go over Graham versus Connor. Disclaimer, the United States, I represent the United States. I do not represent you. I do not provide you legal advice. I am not your counsel. There is no attorney-client relationship. I am not soliciting an attorney-client relationship between us. You can't say I'm your lawyer. Clear? All right.
Referring to?
I'm not giving legal advice. I'm going over for informational purposes what Graham versus Connor is.
Gotcha.
I'm not your lawyer. All right. Graham versus Connor, in 1989, the U.S. Supreme Court, Justice Rehnquist, writing for the majority, says, "It is not subjectively what you believe, officer. If I say I was in fear, so I shot the guy, that don't cut it. From 1989 forward, it must be objectively reasonable." How reasonable is an officer in that situation? That is not, Jonas was the officer and Jonas thought he was reasonable. That is this concept of an objectively reasonable person in that situation. Would that objectively reasonable officer have acted in that way and used the force that way? The Supreme Court lists in that case only 3 specific enumerated factors. The Ninth Circuit has made many other factors since then, but here were the 3 main ones and the prism through which all uses of force should be assessed. The severity of the crime at issue, whether the suspect, okay, that's their term, suspect, posed an immediate threat to the safety of the officer or others, whether he, that is the suspect, this is the Supreme Court's terminology, is actively resisting arrest or attempting to evade arrest by flight. If those 3 things are occurring in any measure, we should look at those as
indications of whether or not force used was objectively reasonable. And their absence, if any of those three are gone, should also weigh upon you when you assess whether force used was objectively reasonable. You do not have to have all three. You do not have to have 2 of 3. It has to be objectively reasonable. Very quickly, going through the force provisions. Paragraph 66 is force policy. 67 is force policy and procedure, and it specifically includes de-escalation, disengagement, specialized units, and least force alternative. 68 is separate on ECWs, that is the tasers. So there's a force policy and there should be a taser policy. Force policy is the umbrella, taser is the specific policy. Taser falls under the umbrella of force. Use of force reporting is 69. Next slide. Here we go, the meat. What can you do to independently assess implementation of paragraphs 66 through 69 on force? My suggestion, don't have to do it, it's my educated suggestion based upon years of having done this type of stuff. Appoint 3 specific COAB members, people who have a specific interest and time in this, to review the force policies. Take part in the force policy review. Dennis is going to review the force policy. I'm going to review the force policy. You guys can take part in that force policy review. It doesn't mean you get a veto. It doesn't mean they have to do what you say. It means your input's important. Review the COCO quarterly compliance report. This current quarterly compliance report is a statement of what will happen. We've only done a little bit and what will happen. For this and all other provisions where I say review the COCO quarterly compliance report, take a look at the first quarterly report, come back and tell the COCO, I don't think you're looking at the right data. You should look at data XYZ instead. Or, I like what you're looking at, COCO, that's appropriate. Validate it so that his report has some legitimacy to the public because you too would have chosen those data. Apply a look behind at a sample of use for force reports. It took hundreds of hours to go through the use of force reports in Portland. I don't think it is fair to ask of you as volunteers to go through every single use of force report. Dennis has another job. He's busy, but he's got some help. He's getting paid to do this. I'm getting paid to do this. He's going to look over use of force reports. Brian Bueller, Aaron Brown, me, we'll look over use of force reports. Gather a sample. A sampling methodology is what I do in all of my cases for my experts. You go and you say, I want a random 10%, or I want all use of force reports involving juveniles, or I want all use of force reports involving tasers. Get that subset, get the sample, get something digestible and small enough. Do an audit of the audit. You don't have to do all the work yourself. Make it digestible and small. Do it as a group. Come with a subcommittee that will assess force. Have them decide what that data request should look like. Make it formalized, make it normal, make it standard so that every month you're getting the same sort of subset. And if it looks like that subset's not good, you can go back and reassess later. Apply your community reports. You receive information from the community here. If I'm asking you to independently assess implementation of the settlement agreement, don't do it just upon the PPB's data, just like we didn't rely only upon the PPB's data. Use the people that come to you and say, no, I had this interaction and it was a poor outcome. I'm not saying it's justified or not justified. I'm saying that that's external data that you can use.
Question.
Yes?
With the report, is the report going to be made available in hard copy to the community for people who don't have computers and access to internet? Because how else are they going to get the report if they don't have internet or computer access?
So my suggestion is that the COCO has the report and will likely post it. My suggestion is anybody who wants it, go ask the city for it, including hard copy.
Falls under the city's accommodation request.
Okay. And can I, while I'm talking, I just have to say this, and it's more or less of a comment, and I wrote it down just so I can make sure I articulate it right. So, by way of what we're looking at right now, paragraph 60 to 69, we've been offered to make policy recommendations for review. What good is it if we make policy recommendations if the only thing they're going to hear is our voice? This is not coming, it's coming from myself and a collective of folks who have thought the same thing. And then 2, for years, matter of fact, since 1829, which I just found out today, I know folks who have been low income, black, Latino, every ethnicity, Burmese, whatever you can think of, we've always been on the downside of power. So I know people who walk around my community every day and they wake up in fear of their life. They're not carrying a gun, they walk to school, they go to PCC, they work jobs, but they are in fear of their life. Not to say it's okay for them to have the use of force and shoot a police officer or shoot a constituent from their city. So it seems a little funky because I wake up in fear. I have a license and registration and insurance, but every time I'm tailgated, I still get a little nervous. I'm a very confident man. I feel very unconfident when a police officer is behind me, but I'm not here to point the finger at police officers because I have those in my family, I have teachers in my family and clergy folks. But since 1829, folks have always been scared. They have always been in fear for their life, for not even doing nothing, just being in existence. So it's a little disheartening to say that, people who have power can use their weapons as force and potentially murder or kill someone. And it's always the officers who are not in the room that need to hear this. And it's the ones that are here, I think we already know this, but the ones who probably need to hear this most and be here and get this one-on-one training, they're not here. I don't know who they are exactly, but I know just in my living, I've seen it over and over, and nobody is having any comfort for the people who've been murdered or killed or wrongfully convicted or wrongfully arrested. And I just had to say that because if I didn't say it, I would go home and I would think about it all night.
Emmanuel, thank you. I hear you. You have taken the time to come here to be part of this, right? So you say, what good is it going to do to be part of the conversation? It's going to be good to be part of the conversation on the policy because it's a further investment of your effort here. As a group, you can come to recommendations on the policy. As a subcommittee, you could discuss the policy. You have to be part of the conversation or you won't set the policy. The policy is what you use to govern police officer actions. You cannot discipline somebody unless it is governed by a policy. I can't fire you from a job where you're protected unless I can come to a finding that you violated what you were supposed to do. The policy is important. You say you should reach officers that aren't here. That policy is supposed to reach every single one of those officers. And we'll get to the training, and that too has to reach every one of the officers. Let me keep running so that we can try to get this done. 940s, or paragraph 70. These are the after actions. Supervision is 71. 72 is a 940 checklist. Checklists are very useful when you want to have a formulaic assessment of supervisors. 73 is the policy on chain of command reviews of 940s and EIS entries. Next slide. 74 is use of force and 940 audits. Okay. 75 is audits of supervisors. So are they using those reports? 76 is trend analysis. Are you using the reports, PPB, to do a trend analysis? 77 is chain of command review of force. All right, again, the meat. My assessment methodology recommendations for 70 through 77. Review the COCO quarterly report. Remember, I like the data, I want more data, I want different data. Voice your concern. Apply community reports. Again, what you hear. Review PPB force auditor and COCO audit. So you need to know what the world's data are in order to do an independent assessment. The data that exists are use of force reports, incident reports, arrest reports, maybe property seizure reports, 940 reviews of use of force. And you all have been trained on it already. The supervisors go out there and do the 940s. One of the other data are an audit they already do. PPB has to do an audit. Dennis has to do an audit. You guys should do a look behind that audit. Does it make sense to you? Sample, again, look behind for a sample of 940s. It would be unrealistic to expect this group to go over all the 940s. Small sample. Validate it yourself. And then, again, consistent with paragraph 151, apply recommendations. So any recommendations are subject to a full vote. Bud, yes, sir. Excuse me, Bud.
To applying a look behind, when you think of the COAB, how deeply are you expecting us to look? Because I'm just wondering, do you see us interviewing police officers, or what do you mean when you say that?
If you wanted to invite a police officer to speak, I believe you could do so. I do not believe that this organization has the authority to demand the presence of any city employee, and that would implicate their garrity rights. It would implicate their right to representation. They may object to showing up. I would encourage you that it is attainable information to find out whether or not there's compliance by looking at the reports themselves. And if they don't answer the question in the reports, then there's a problem. If you want to do further interviews as a group, come up with a recommendation for a data request, send it through the COCL to the city. You can ask the city to send somebody here to talk. And you'll see in some of my later ones, I think you should ask. Training. Group them all together in one slide here, 78 through 87. Training has to be on constitutional standards. They need to have an annual plan. They need to have effectiveness data. They need electronic training records. They need semi-annual training report. They need a trainer selection criteria, current policy on training. There's a separate, again, COCL and inspector audit of training. 86, there's a COCL inspector quarterly data presentation, and the COCL and the auditor are supposed to identify deficiencies. All of those things easily reviewable. 87, open training advisory committee meetings. Again, here's my take home. Paragraphs 78 through 87, assessment methodology recommendations. I would encourage everybody here to take the Civilian Police Academy training. If you want to judge police officers, learn how they're trained. If you want to see how they see the world, try to walk in their shoes for a little bit. They should be empathetic with you, and you should be empathetic with them. We should be better to each other as people, right? Emmanuel, as human beings. Like you said, we should try to treat each other well as human beings.
Side comment.
Yeah, that's right.
Are we able to go, I'm very interested in the trainings, and that's really my focus for being on this COAB. So my question is, do I need the COCL's approval to go into a training to observe, collect information? And, you know, I'm not going to be getting any raw data from it, but, you know, just basically learning what's going on in the training, learning what's lacking in the training, and just doing a general observation that I'll bring back to one of the COAB subcommittees that I'm on, and then bringing that to the full COAB meeting. So I'm just asking, do I need permission from the COCL, or what is the approval, or what's the process for that?
Yeah, I mean, I can respond to that just generally, which is we just want to coordinate. I mean, if we can avoid overburdening them, I mean, I see the police are here, they might never respond to this more directly. I went to training this morning. I'm sure you guys could. You want to respond?
So
to
the
that?
executive committee did list attending the citizen training as something they'd like to see as mandatory for this entire group. We're in conversation with the training department to set up probably 3 consecutive Saturdays where that would be available. So we'll need to do it in smaller groups, but it's in progress. And we're looking at, I think, end of June and very beginning of July, so about a month and a half out. Yes.
Philip, I understood your question differently. I understood your question not to be COAB going to the Civilian Police Academy, but rather direct observation of training. Yes. Short answer, yes. My encouragement to you is, in order for this group to maintain its credibility in its assessments, don't be ad hoc. Don't just do it. Be thoughtful, considerate, and systematic. Get a list of all the trainings. Take it back to your subcommittee and decide which ones you'd like to see. Tell the city, I'm going to show up on this date. Tell the city how many members of the COAB are going to be there. Don't be, as I've found in my work, I'm not accusing you of doing this, don't be disruptive. Because if I walk through with an expert and 5 lawyers into a developmental disability center, whatever active treatment they're doing for people that live in that center is going out the window. It's disruptive, and it's going to destroy the training. So I'd say keep the group small, be considerate. Here's one of the other take-homes on the slide. Training Advisory Committee, I think that you should invite them to present, if not to the whole COAB, to your subcommittee, what they're doing. Training Advisory Committee are civilians who are advising the police. Let those civilians give you their perspective, not just the police bureau. Yes, Rabbi.
It seems that for our purposes, the delta is really important. What's the difference between what was training before and current training? How do we find that out?
I don't believe that there has been a great deal of change in training, except for the policies that we've already gone over. DOJ and AMAC already went over 1010, and the city implemented 940. They've done training on both of those. The other sort of annual trainings, I'd be surprised if there were dramatic changes. What I would suggest you look at is the annual training assessment the PPB is supposed to do. They should identify in there what the deficiencies were. That would give you your first easy indicator of how things have changed. If, after looking at that, you determine there's a need to look at the raw data, then you could request the old training curriculum. May I suggest to you, however, that that may not be the most efficient use of your time, because the training assessment itself should identify that for you. From the COAB, I imagine that you guys will put together, people will put together a subcommittee on policies. I suggest you have 3 people go over policies. When you have approved the policies, make sure the training is consistent with the policies. Again, review the COCO quarterly report. I like it, I don't like it, this is what you should change. Apply community recommendations. This is what the community told us. And any recommendations, any formal recommendations from the COAB are subject to a vote. Community-based mental health services. You have seen, I'm sure with much consternation, that the community-based mental health services we have identified as aspirational. We wish you guys would do this. Again, what was our jurisdictional reach? The police bureau. We could not reach the county. We could not reach the state on this case. But the Adams administration was willing to include in the settlement agreement the aspiration that the city should work with its partners, and the partners should establish a handover facility. And the settlement agreement, excuse me, we have referred to it as a walk-in center. I think it is more accurately characterized as a handover facility. One does not merely say, I'm a police officer, I'm leaving you at the door, go walk in. First responder may summon EMS, first responder may facilitate a mental health hold, first responder may facilitate a mental health professional walking somebody in the door, but then there is a handover of care, not a disowning of care.
So is that going to be reported on from the COCO, and has that happened?
Has it happened? No. How many are familiar with the Legacy project going on right now? So on this side of the river, there's the old state hospital. Legacy owns property. Legacy is working with other stakeholders right now, included in our statewide mental health case. Adrian right there is your point of contact for our statewide mental health case, as well as Jess Polanski, the attorney from my office. They are working on a private provider, it'll be a nonprofit provider, creating that sort of handover facility right now. PPB then will have to have a role in what policies they will employ to do the handover. All right, I gotta hurry up. My suggestions for assessment methodology: invite the BHU and the BHU Advisory Committee to present to the COAB. This is pretty crucial. You guys may want to do this as a group. Review the COCO quarterly report. I like it, I didn't like it, here's what you should actually do. Use expertise in this COAB. There are physicians, there are people with lived experience, there are qualified mental health professionals, there are BHU members. Use the expertise of people on the COAB to contribute to the discussion about the Legacy project. It is an ongoing public discussion. The city has already dedicated $500,000 in the coming budget as a proposal to this. The state's contributing money. Legacy is contributing money. Private providers are contributing money. Join the conversation. Handover policies. You should review the policies. Apply community reports, what you hear. Any recommendations subject to a crisis intervention. Crisis intervention includes paragraph 91, BHU, mental health data, outcomes data, BHU advisory committee analysis, and advisory committee reports.
So I just had a question in regards to recommendations based on if a single member from the COAB puts recommendations or solutions on the website and is speaking directly to the city and to the police bureau, then should they not respond in some format to that, what is put up there, and to have something to say? Because I myself personally have made recommendations and suggestions already, and it feels like it's fallen on deaf ears. So when it comes to group recommendations versus individuals from the COAB who are taking in this experience and giving feedback, I would like to know, how does that stand?
There is no requirement in the settlement agreement that the city respond to every single inquiry from the COAB. There's no requirement that the city respond to every single recommendation from a COAB member. Let me suggest to you, it would be unfair for Corey to walk up and say, I'm speaking for the COAB. It'd be unfair for any individual to speak with the gravitas of the entire COAB without going through the paragraph 151 requirement. It would also be unfair to limit the online conversation that you all have set up through your online board. Continue your conversation, use it. Everybody's busy. Use the online board, have your discussions. You can have suggestions on there. When you come through the process of distilling down your recommendations or gaining the support of the COAB as a whole for a recommendation, bring it to the vote. If it's a good initiative that you think needs a lot of work, take it to a subcommittee. Apply paragraph 141A through E, see where it fits, make sure it's within the scope of the COAB, and then go forward from there. It would not be a realistic expectation that every time I think I have a good idea that I require Ellen to respond, because she already has to respond to me a lot.
Simple solutions, simple.
I hear you, and simple solutions are great. You can expedite those. Make it something for a vote next time. Community mental health and crisis intervention goes on. See, crisis intervention, it's paragraphs 97 through 103. There's a whole section there about the Memphis model and crisis intervention team. It's terribly complex. It's very difficult to just learn off the cuff what a crisis intervention team is. And this city has a pretty robust system that they have changed since we walked in the door. Paragraphs 106 through 110, mobile crisis prevention team. Yes, Senator.
105.
Yes, ma'am.
Data collection. 105B requires collecting subject's name, age, gender, and address, but not race or ethnicity.
If you would like to make a recommendation on change, we could do that. But I think we should probably actually look at the SITREP reports because they probably already include that.
They do? Did someone say they do? Okay.
Yeah.
Yeah, my concern is that we not continue insufficient data collection.
Valid point. I hear you. Mike?
Sorry to interrupt. We actually added that into our data field, so that's already been captured.
Okay, but again, it's not in the settlement agreement.
True. We just did that on our own and enhanced it on our own.
Great, thank you.
An oversight. There was only one perfect guy, and I'm not him. We didn't get it right. Paragraphs 111 through 115. These include BOAC. Remember, the defendant is who? The city, not the police bureau. The city includes BOAC, even though it has a different commissioner. BOAC is important. BOAC is Bureau of Emergency Communications. 911. If I call 911, should I automatically get a police officer? Not all the time. Police officers shouldn't always have to be the first responders. There are requirements for triage policies and training. Here's my take-home again for paragraphs 91 through 115. Invite the BHU and BHU Advisory Committee to do presentations to the COAB, review the COCO quarterly reports, review the policies on mental health, review the BHU SIT rep reports and newsletters. These are another group of data that are existing out there right now. You can go online yourself, as anybody can, and pull down from the city's website its BHU newsletters, and the SITREP reports come out about once a month. Apply community recommendations, and any COAB recommendations are subject to a vote. EIS, Employee Information System, used to be called Early Warning System. This is career-saving safety net, if you will. Very quickly, I had a police officer in another department who lost his career 4 days before his pension vested. And when he lost it, they said, oh, we knew he was always doing that with those cars anyway. Why'd you wait? If you know, because you have an early intervention system, that somebody has a problem, save them from hurting somebody else or themselves. EIS, in this town, they actually have a pretty complex EIS they've already set up, but they were nascent when we started. There are requirements for the EIS in the settlement agreement. Here's my take home for paragraphs 116 through 120 concerning EIS. Invite the EIS administrator, Bud, in response to your question about should the police officers come and talk. Here's where I think you should invite a police officer here to talk specifically about what his job is. This individual over there runs the EIS. It's complex. Have him come in here and teach a class on it, or to your subcommittee. If it's so nuanced that the whole group doesn't want to know about it and 5 people can do it, have those 5 people do it. COCO quarterly report. I like it, I don't like it, here's what you should look at. Policies on accountability. Apply community reports and recommendations are subject to a vote. Officer accountability, paragraphs 121 through 27. And paragraphs 128 through 133 with a nod to paragraph 172 has another requirement in there. Again, I'm going to give you these slides. Here's my take home. Invite the IPR director to do a presentation to the subcommittee. Rochelle, no doubt, knows the system very well. The system here is so Byzantine that all of my experts think it's too complex to understand from the officer's perspective and from the complainant's perspective. It's not fair to either one. You can't have a system you don't know the outcome. You don't have a reasonable expectation of what outcomes should be. Appoint 3 COAB members. My suggestion, again, to participate in accountability enhancement discussions. Review quarterly reports, et cetera, et cetera. All right, we're getting toward the end. Community engagement outreach plan. The last substantive area, your CEO plan. The settlement agreement says that the PPB is supposed to put it together, but the COAB is supposed to contribute to it. Important piece. If you have a community plan and the community plan only comes from the police bureau, it has no credibility with the community. If you have a community plan that only comes from the COAB, you're completely losing the benefit of all of the resources of the police department that's done community surveys in the past. This is the time now to appoint a few people from this group to work with the police bureau to come up with a CEO plan. Yes.
So, going back just to is the only way to make a recommendation or suggestion that will be heard by the city and PPB is for that to come through a vote of this COAB, or can the general public send in, how are we going to find out whether or not someone has posted something on the website and the city has taken that in from the website as a suggestion or idea that's come from the public, and how will the public know that? I mean, really, I'm really trying to understand the process of community engagement and really what that looks like, and the process of real community members.
I might be able to answer that. If anyone posts online, you can take that suggestion, and we can take that to the committee and then bring that forward to the full COAB for a vote, and then we can take that to the COCOL as a recommendation. Is that correct?
Yes.
That was my question, I'll say that.
If it is a COAB recommendation, it must be voted. If it is an individual recommendation from anybody in the public, they can post it to the city's website. There's no requirement that the city has to respond to every single thing that they get.
And that wasn't my question either. I'm just wanting to really know when the public does post ideas and suggestions, you know, how do they know that the city is looked at that and will respond to say, because the public is looking for the city to have, that's the engagement piece, is whether or not they're listening and looking at that information and the response back, that's part of the policing, community policing, is that they're being heard.
We have to follow up with the code
Yeah.
review that if the suggestions and recommendations have been gone through, and so from the community, and we can let the community know what we've passed on through the COCOL.
And just in the interest of time too, because we still have the quarterly report to present today. And 10 minutes is for the public comment, which comes next, which is supposed to start at 8:05. So we're gonna, as soon as, I would recommend that the subcommittee that deals with community outreach take this up and talk to us more. I mean, I'm sure we can. Yeah, is this about this issue?
Just to bring back on, Rabbi Connor asked a very good question about training that was and how it's changed. And to clarify the comment is there's a lot of training that has changed in significant areas, well before the agreement came into place, as a result of especially the Aaron Camel incident, and that's kind of what got this started. So there are a lot of different places that things have changed, both in behavioral health, both with ECW, with de-escalation, significant areas. So hopefully part of that Citizens Academy, Community Academy will be able to get that information out. I know what Stephanie Prival's got, who reviews all of our directives and policies, will be able to get some of that. There's a lot of different areas to look that information up, as well as lesson plans from individual in-service dates and advanced academy trainings throughout the last number of years. So significant changes have been made. Are there more to be made? Absolutely. But there have been quite a few that have been made already.
I can finish. You can be done. Hold on. Thank you. I welcome the correction. Last take homes. Be focused to be effective. If you try to do everything at once, you'll accomplish nothing. Try to accomplish what's before you right now. Paragraph 141 and the 6 substantive provisions. Try to get that done. Last take home. We want you to succeed. The object here is to have a credible assessment by you and to get back to that Pelian principle. More public faith in the police means less need for use of force. Let's heal the relationship. Thank you.
Thanks, John. Okay, if anyone needs to take a break, you can, but I think we need to move on to the 10 minutes of public presentation, and then we were going to cover the quarterly report at the end just briefly. I'm not going to spend much time on that, but also on the agenda, the opportunity we were going to have for business that we, issues that we haven't covered, things that you would like to be covered. I think what we'll recommend for now is that you send those by email to us, and then the executive committee could discuss those and see what to do with them for the next meeting, if that's all right, because we're not going to finish otherwise. So, and we can send them to our, where should we send the comments?
I will send out this slide deck and post it on the site, but when I send out the slide deck, you can respond back there if there's things we didn't cover or something we need to go in more depth on.
Yeah.
That the subcommittee worked hard on and made and did information sharing in an effort to make recommendations today that needed to be voted on to move forward for a timeline that is coming up in the next week. How would you suggest we proceed with that? Because June 11th, the next meeting, May 28th, is dedicated to something else, and June 11th is beyond the timeline for
We may
feedback.
have to request an extension on that. It's DOJ. Where did Jonas has gone now? So there's a deadline coming up for mental health review. They've spent a lot of time on the subcommittee making recommendations, reviewing the policies. Yes, and they don't want to miss the deadline if we don't talk about it tonight. And when is, you know more about this than I do, the deadlines.
These are policies 850.20 through 850.22.
So if I could recommend, if we could send around the recommendations by email, this group can review over the next 2 weeks, and then we can have an expedited vote at the May 28th meeting? Would that fill the timeline?
Is that missing?
So we had at least 14 days after So I think that it would meet that timeline. I'm not remembering, Sharon.
It's 14 days
That the
after
14
May
days
2nd.
after May 2nd. So I think we'll miss the deadline actually if you do it that way.
Okay.
So what?
Let's connect after this, and we can also talk about whether there can be an online vote.
Exactly, an online vote, that would be a great idea. Because we have worked exceptionally
A lot
hard.
of good work has gone into that. We appreciate all that work that you've done.
In
So.
terms of timelines, we've gotten significant feedback on those directives, so they actually are, the timelines will ultimately be extended. So I can get back to you about what the timelines are, but there may not be as much pressure because of the significant feedback we've gotten all around. So they're in a reconciliation process is what we call it. And so it's important for us to get your recommendations, obviously, but I don't think you'll be outside of the timeline.
So can we work with the chairs and with Ellen to make sure all the timelines align?
Yeah, and Dr. Watson, you've been working with her too on our team, and I think she's been raising this issue too. So we'll make sure it doesn't happen. That all your good recommendations do not miss the deadline.
Right, and then at future meetings, of course, we want to designate time for the subcommittees.
Yes.
Sorry,
yes.
I'm on call this week, but we want to designate time for the subcommittees to share all of the work that we actually have been doing. So that should be on the agenda moving forward.
Okay, great. Thank you, Dr. Moreland.
Can we give respect to the alternates that are here and see if they would like to have a comment before public comment? Because
Well, they're part of the public comment. That's the rule that was laid down by the Justice Department. They are part of the public at this point in time until they're members of the COAB. So they can speak now too. So why don't you handle this? So we have several people signed up. We have how many?
We have 3 people signed up. We have Dan Handelman, Rena Rem, and Brian Thompson.
So I want to do it
That
as
doesn't
a
negate the
community
fact that she's
member
got
reporting from the community.
That seems a little odd.
But she's still public.
Chicago.
Yeah. Okay.
Hi, Dan.
Yeah. That would mean anyone who comment, but the rules were you needed to sign up. I mean, how does the COAB group feel about COAB members using the public 10 minutes to speak? Yeah, go ahead.
If there's time after the public has spoken,
Right.
then that could be filled.
Okay, and after we finish the agenda. Okay, that sounds reasonable. So you would speak as a member of the COAB after, if there's time available. Okay, let's get going here.
Hi, I'm Dan Handelman, and we're the group called Portland Cop Watch. I think you've seen me here before. I'm very disturbed by, once again, this assertion that there are no statistics to show that there's racial profiling in Portland. We shared statistics that came from the police bureau that I can go over with you in greater detail later, not only about traffic stops, about searches, about contraband found, about the gun exclusion zone, about the people who died at the hands of police shootings or were shot at, way outweighing the African American population that the DOJ had. The racial profiling plan is listed as in the settlement agreement. That wasn't mentioned. I think it's important for you to realize that that's part of your focus as well. The DOJ has, since they've come to town, there's been multiple shootings by the Portland police, and almost all of them have involved people with mental illness, and several of those people have been homeless, and a couple of people have been people of color, and I think the patterns haven't changed that much since, even though the Bureau knows that the DOJ is in town. For those of you who don't know, on May Day, the Portland Police released a lot of weapons at people in the crowd, often indiscriminately. They're not they're tools, they're not weapons. I mean, they're weapons, not tools, which is what was referred to as before. These 30-day timelines do not work for you because your meetings may happen more than 30 days apart if you're having them once a month. So I think that the 30-day reviews of these incredibly long quarterly reports have to be extended so that this body can vote on their recommendations at the next meeting. I think people could split up these complex reports. There's 15 of you that you may be able to read more reports when not one person tries to read all of them. The Training Advisory Council voted at their last meeting to hold their meetings on the same day that you're having your meetings, which I think was very unfortunate. You should talk to them about that. I'll try to type up the rest of my comments and send them in to you. Thank you.
Thanks, Dan. And next we have Rena Rem and Brian Thompson.
Hi, my name's Rena. I live in North Portland, and I'm here because someone from my support system suggested I share my story of an interaction I had with 2 officers on the Max. I was taking the Max home from work, and I noticed like 2 cop cars at the transit center, and I noticed that they were handcuffing a young black gentleman. And then I get on the Max, and 2 white officers bringing the handcuffed gentleman onto the Max also. And that was just really, I just hadn't seen that before. So I asked the cop, I'm reading what I wrote earlier, just so I don't leave out details. So I asked the cop, so do cops always take the Max? And he said, sometimes yes, if I don't have my car, I'll use public transit. Why do you ask? And I was thinking about the man in handcuffs. Do you think about how humiliating this is? What do you mean? You've already arrested him. Why do you have to bring him on the Max? Like I said, if I don't have my car, I'll use public transit. Are you trying to humiliate him? Do you not think he deserves dignity? I can tell you this much. He is a criminal and has a warrant out for crimes. And what about his dignity? What are you getting at? And I was just really upset at this point because I felt like he was being really defensive with me. And I said, never mind, I'm not going to get into this with the white cop. And he said, what's my skin color have to do with this? I find that racist. And I said to him, you have no idea what racism is. He asked me, what's racism? I said, racism is institutionalized. At that point, he scoffed at me and just repeated that back to me, like, racism is institutionalized, yeah, right. And then the 2 officers got off the Max. So do what you will. Thank you.
Rita.
Brian Thompson and then Laura Vanderlyn.
Hi. First, I want to thank the COAB for their volunteer efforts. I worked in a Portland Emergency Department as a psychiatric social worker for many years. I interacted with dozens of Portland police officers who brought patients on to the emergency department on police officer holds. I would say maybe 2 or 3 a shift every single day, and that's just one Portland hospital. Overwhelmingly, the police were dedicated, caring professionals. They have an extremely difficult job. I remember one night, middle of the night, police brought in a gentleman, psychotic gentleman, was wandering without shoes, and the police officer just said, I just couldn't let this guy, wander the streets. That's not going to make the front page of the Oregonian, but I think that's just one small example of the good work our police officers are doing every day. I think that's important to acknowledge. From my perspective, the biggest problem is our disastrous mental health system. There's a woeful lack of treatment options from the state hospital to outpatient, especially for chemical dependency drugs and alcohol. It's not unusual that patients will wait in the emergency department for days, for several days. That's not unusual at all. And I think until we address that, we're going to continue to have police interacting with people in crisis. I think bad outcomes are inevitable as long as, really, we as the citizens of Portland and Oregonians, this is something we have to address with our leaders because the care system is failing us. And I think we're putting a lot on the shoulders of the police, expecting them to be social workers. We shouldn't ask our police to be social workers. A social worker, it's not rocket science, but it's a difficult job. And to say we should expect the police to do everything that they're doing and be social workers as well, I think is it's inappropriate. As a society, I think we need to address the lack of mental health treatment in Oregon and Portland. So, thanks.
Laura Vanderlyn and Nancy Newell.
Hi, I just wanted to say 3 things. There is something in our system that says it's okay for police to kill with impunity. 2, police are not held accountable when they are killing with impunity. And 3, police don't live in the communities where they kill with impunity. If you live in the neighborhood, if you live and you work in your community, you're most likely not to kill somebody. We need to hold police accountable when they kill. We need to hold police accountable when they use excessive force. They are not being held accountable. They are not being prosecuted. They are not being jailed. So when I hear we need to figure out how to interact with the police, we need to hold police accountable. We don't need to interact with them. We need to expect them to do their job, to police, to protect and serve. I have immense respect for the police. But if I commit a crime the same way a police officer commits a crime, I am held accountable. I want a police officer to be held accountable the same way that I am held accountable. There is something in our system that says it's okay to kill. That's for our police officers to kill. We also have vigilantes because they say, I'm scared. It's okay for them to kill. This is not okay. It is not okay to kill with impunity and not hold police officers or anyone accountable. They need to go to trial. They need to be held accountable. There is something in our system that says it's okay to kill a black life. There is something in our system that says it's okay to kill a black life. There's something in our system that says it's okay to kill a black life.
Nancy Newell.
Hi, I'm Nancy Newell. I've lived in the community 23 years, and the mayor just announced, he's our police commissioner, that heroin, methane, and cocaine has increased rather dramatically in usage, and these activities are being detected. And I'm wondering what impact that will have on this whole process, because if there's a lot of activity in neighborhoods that are falsely accused of drug centers, and youth are suffering from raids, or raids in our neighborhood where they go into the wrong house and not even tell the neighbors what they're doing as they're in this activity, and we have no clue where we should be or what we should be doing as we're walking on our sidewalks during the day. So there are questions that I have. What's the interrelationship between the police and the FBI, and what is the accuracy of these statements that they make in the press? We don't really have trust in these kind of reports because of some of the situations that have developed in the past where funding seems to flood into all kinds of instruments of destruction of human life from just reporting that this is increased. So I would like the surveyor to somehow include whether that affects your survey in tracking if they're doing it accurately, if it is certain areas that you can really pinpoint and legally prove that that's the case, because there's too much racial profiling of these kinds of activities. And I know that the higher echelon of wealth in this city uses far more cocaine than any other group. So nobody takes care of them. Nobody takes care of police officers in trouble with drugs. I mean, we're on watch. We're going to be running on TriMet, where now we're going to have no money, just an electronic system where everybody checks our background. That's enforceable. So-called trusted police officers, oversight people. Why should they have that right? I don't understand why all these violations of our Constitution are being allowed in this city. Thank you.
Okay, as usual, I get 5 minutes at the end. I'm gonna have to put myself on the agenda sooner. So we do have a quarterly draft report. You can go on to the next. The COAB there should be enough hard copies for all COAB members. Is that right? You already. These are extra. These are extra. Okay, good. So these are. So let's see. Actually, use the mic. Okay, I'm Dennis Rosenbaum. For those who don't know me, does this work?
There's a little button.
I don't really. Try it. Oh, okay. Actually, this is my version of Jonas's. What are the key elements of the settlement? He's a lawyer. I'm a social scientist. I speak more English than he does. So this is simplifying the things that he just talked about on all, but with much greater detail. That we're trying to change the way that I see it doesn't fit on the page. Well, that's too bad. That's my fault, I guess.
it's collected document. I'm not going to, you will get this, so we're going to get out of here at 8:30. I promise you. So we're not going to go through this right now, except to say these are the key areas where the Portland Police Bureau is expected to improve itself and its relationship to the community in the settlement agreement. Okay, let's go. Oh, this is the rest of them, the other ones, these systems. Okay, this first report, I should say, does not have a lot of findings yet. We spent a lot of our time getting a feel of the ground in the city of Portland, and we've talked to. Here's some of the things. Here are the tools that we're actually using. We lay this out in the report for you that we're using to help do this process. Help facilitate the COAB and town hall meetings so that we can get the community input that we need. Interview stakeholders. We've done a lot of that already, but we're also continuing to do that. It's another way to find out what training and all these other things have been done in the past. And observing the process. I spent from 7 till 11 this morning at the new training academy watching the police be trained. And not only that, there's a lot more involved here. What are the processes involved in developing policy? We do talk about that. The whole process of reviewing use of force. A lot of these are things that Jonas is alluding to. Gathering and analyzing the data on trends and the effectiveness of these reforms. We'll work with you guys on that. I'm a little concerned about the language of we're auditing the PPB, having the COAB auditing us, everybody's auditing everybody. I see us as working together to come up with plans for auditing and evaluating the Portland Police Bureau. Conducting surveys of officers, that's starting. The community members, we've struggled with that, but there's a plan put together by the executive committee, which I thank you for doing that to move forward. Reviewing all these documents. Another way, just to go back to your, how do you know what training was like before? There's training curriculum and there's changes of when they were introduced. And we write reports like the one you have today to summarize, evaluate, critique, and make recommendations. I do want to say that we have gone ourselves, because we've been, or at least myself and the team has been studying police around the United States for 20, 30 years, but also studying 100 cities recently. I did have recommendations for Portland that would help push the community agenda to push community policing in Portland. So we threw in a couple recommendations. They're not required by the settlement. I am curious, the COAB hopefully will share some of those and see if you have more. But there are things that can be done, I think, to help achieve the goals of the settlement in other ways. All right, is there anything else in here what else do we have? Oh, what are we at? Here is the basic, to really simplify this stuff. Did the Police Bureau do what it was supposed to do in the settlement agreement? That's more of a yes or no kind of thing. We don't stop there. That's the check the box approach. How well did they do what they were supposed to do? How thoroughly, how conscientiously, how many resources were committed to it? How good was it? What was the quality of the implementation that occurred? Are there additional changes that are needed to be in compliance? There's a big thrust, and I appreciate learning from the Justice Department about the extent to which every part of every policy and every paragraph in that settlement agreement is complied with. And the PPB, I think, to this date, I have a lot of confidence. I'm from out of town, so I appreciate all the history that's gone on here. I realize there's a lot of pain and suffering in Portland that has gone on. But I also, since I've been here, and I guess Jonas said the same thing earlier, I didn't realize he felt, but there's been a lot of, we feel the intention of the police department administration here, as well as the city, is to work with us to get this done. We have seen a lot of cities, I can name them, where they fought these settlement agreements. And I've also sat in the room with many police chiefs from these cities who said, don't fight the settlement agreement. It took 10 years instead of whatever. And but I think I don't see that in Portland. So I think that's a good thing. I'm talking as an outsider now. Can you back up just? Sure, go ahead, Phil. As long as we get in by 8:30.
Could you back up? I couldn't see
any, so of the comments, because I was reading, but you
Sure.
said, so the COCO will accept recommendations from COAB. And then I missed what you said about the,
This one here, right?
I don't see anything related to the COCO that says the COCO will accept recommendations from the COAB. Maybe I missed it, or maybe you referenced it when you were talking, but I don't see anything in there.
I don't really
In the
even
past slide.
separate the COAB and the COCO the same way that others have. I see us as working together. So your recommendations, I mean, this is a longer discussion, I think, but there's no question about that. It's designed when I speak, I'm speaking for both the COAB and the COCO, actually, I should say, when I make these comments.
Okay, I just wanted to clarify.
And did the reforms make a difference? In the end, you have policies, then you have training to implement the policies, then does that training translate into behavior on the streets? Does it really change anything in the police bureau? Does it change also the community's view of the police, which is the ultimate goal of some of this stuff? And so that needs to be documented. And can these reforms be sustained over time? You do not want to waste all this effort over the next couple of years and find out that things went back to the way they were after DOJ left town. That requires institutionalization. Okay, I'll stop there because there's a couple of quick questions. I don't have any more slides, do I, that are worth talking about? I'll just make these real quick. This is preliminary observations. You'll find this in the report. I said this, I feel they're committed to reform. The city is working with us. There have been some challenges we document in the report. And we're devastated to lose Paul DeMunis as our local chair here, but we're working really hard to replace him, and we hope that will work out very soon. It's too early, as I said, to really evaluate compliance with specific paragraphs, but we do allude to some areas that are promising. The crisis team stuff looks promising in Portland. Dr. Watson on our team is an expert and has worked with the two doctors here and others on that subcommittee. There are still issues there that need to be resolved. I'm concerned about records management. All the data that we keep talking about, I don't know that there's kind of different silos in Portland, and whether we can get an integrated system to get that data out, all the data that we need is another issue. I know that we've had a rocky start here. We've been through that. We're not going to cover it again now, but I feel confident about the way the people from the COAB have stepped up, begun working together, created subcommittees. We have a good executive committee, and Emmanuel and others, I appreciate all the work you've done to help that, and also great people helping us here. So just a couple time-bound things. I'm really hoping the executive committee is working on the community survey, so that's good. That's Community Engagement Committee, excuse me, I'm giving the wrong credit here. And then the town hall meeting on May 28th. So that's where we actually want you to really talk about this report, which we can't talk about tonight. But a couple of quick questions and we'll let you go. Yeah.
Would you please provide a list of stakeholders so that we have a good understanding of what that universe looks like that you are drawing from?
Well, I was referring mostly to the fact that coming here, we spent a lot of time listening to the voices of different groups. We met with the AMA group right up front, and the doctor and everybody, to get their input. We met with the mental health community. We met with all.
Okay. Now, but as a supplement to your report.
It's in there, I think, who we met with.
I looked, I couldn't find it.
Couldn't find it?
No.
Okay, this is why we have a COAB too. So if you think there's people that's what this is about. You guys represent the stakeholders. So if there's someone that's not represented, we should know and, get their input. So, okay, thank you. Oh yeah, go ahead.
Dennis, you said that you're speaking for the COAB, but did you solicit from us a summary to put in your report, or are you just making general assumptions to say that you're speaking for the COAB? I'm
not speaking for the COAB in this report so much. I am, but yes, we solicited input. We've been listening. We've been coming to these meetings. And if you don't feel it's reflected in there, then let us know. That's what this whole point is about.
Follow up from, since I didn't get to speak for the public, from a community member who did call me today and said that they would like to make sure that the information is truly being disseminated to the community. And I want to find out from Mike Marshman and from you, how are you going to provide for this 30 days that connection with the community other than the internet so that they can have an opportunity to see this report? Because this woman told me, she says, I just don't know what's going on. She's caring for her ailing mother and other responsibilities, and so she can't come to the subcommittee.
I hear you. So this is an important issue, and again, I feel that's part of the COAB's responsibility too, to help us figure out what you want us to do to get the message out. We have our ways, and she can tell you what the plan is right now, other than the hard copies to you. Go ahead.
So there's a sheet on the table on the way out the door that outlines where the report is posted online, the forum, the email, and the snail mail address to send in comments. It also outlines that we're having this town hall on the 28th. We do need to have a conversation with the executive committee about any follow-up training we're doing at that meeting, how much time for COAB discussion at that meeting, and then how much time for town hall comment at that meeting. The report and the notification around that meeting went out to the media this afternoon, letting them know that the report would be online at 5 o'clock. I saw that the Oregonian has already written about it, so it is getting wide attention, and I expect we'll get more.
Different forms, radio, TV.
Correct. All TV stations, all radio, all print media, including community papers. Got a notice about that this morning, and I will.
All stakeholders are receiving.
And that's on my list to do tomorrow, as well as send the actual report to the media. They had the preview today that it would be posted, but I want to make sure it's actually in their hands as well.
One last question, and then we're going to adjourn. So, yeah.
We never really had a chance to process the town hall meeting, and I think there was a lot of emotion that needed to be processed. Who's setting the agenda for this coming town hall meeting?
The executive committee is sending.
With
That's
the
why
COCO.
With the COCO, so there's been back and forth. So the next, I mean, there's still time for that agenda. A good part of it should be devoted to discussing this report, but whatever else you guys want to cover, just send it into the.
Well, the community engagement, we did have a debriefing meeting on the hearing, and so, and invited everyone to come. That was April, our last meeting, so we actually did and sent out the.
I'm sorry, yeah,
the notes.
COAB.
Yeah, it's hard.
The subcommittee, yeah.
The subcommittees.
Maybe we bring that up in the future town hall.
Well, I'd just like to suggest that we have some suggestions for the agenda that we pass that on to Coco before this meeting.
Yes. Amy Ruiz is handling a lot of that, so we're confident that. So do give us your suggestions. It's not too late. I think we need to wrap it up. B, can you do this in 1 minute?
I can do this in 13 seconds, Dennis. When are we going to get a community liaison? Please.
I'm hoping we'll know something by tomorrow.
Awesomeness.
I can't say anything
13
right
seconds.
now, but hopefully we'll have something positive to say. 1829. The people are the police. Thank you all. Appreciate your help. Okay, Amy. Announcements. Let's see. I can't read with glasses on. Please, COAB members, leave your names, tents, badges here on the table. Place them in the bin. Okay. Anyone who plans to attend the next meeting and needs accommodations to help you participate, please see Brad Taylor after the meeting. Brad, where are you? So people can see him over here. If there's any food left over, please feel to help yourself. To move the conversations along, that people are asking people to move out to the lobby so they can get this place deconstructed. They have bus tickets. If you've arrived here by bus and would be helpful for you to have a bus ticket, please see Brad again. Okay, thank you all.